All right, we are going to get started on the the Joint Interim Judiciary Committee. I'm so used to it, even after all these months. And welcome everybody to our committee. Most of you know me. I am Senator Melanie Scheibel. I am the chair. I am in Las Vegas. We also have members joining us from Carson City and also from their own homes. So we have a couple different locations all together through the miracle of technology. I know that most of you have attended meetings before, but I just want to give everybody kind of the lay of the land so that anybody who's new to us understands sort of the way that we run these meetings. They are marathons, so I know that we are going to be here for a little while. My committee members know that they are welcome to stand up, stretch, grab a drink of water, take a break if they need to, and so I just ask that the presenters please, respect that they're human beings too. Don't take offense to it and understand that they might leave and come back and maybe even ask you a question about something that they missed. That's because we are trying to get through so much material in such a short period of time. And with that being said, the way that these work, in case anybody doesn't know, is that we have presentations first. We have questions at the end from all of the members. There is a public comment period at the beginning. There's a public comment period at the end. And we will probably take one longer break for lunch as close to noon as possible. It's a couple minutes after 9 now, so at a good breaking point, I'll try to give you guys sort of a heads up that we're looking to take a 20 to 45 minute break sometime around noon. And because I know that everybody, it looks like we have a lot of people here, we have people presenting online. If you do have scheduling issues, please feel free to bring those up to myself or the staff or whoever you arranged your appearance with, and we can make adjustments to the schedule if you need to get going or want to leave and come back, and we can move you to the end. Again, we're all working as a team here to get through all of this information, but getting through it doesn't mean that we don't spend the time necessary to hear everybody, to listen to your updates, your information, and your concerns. It also means that we don't cut our members short when they have questions and want to have conversations. So I don't want anybody to think that I'm trying to encourage you to truncate your presentations, just to be cognizant of the fact that we are all working towards the same goal here. So with that, I think I covered all of the housekeeping type stuff. We will move first into our first public comment section. Everybody who wants to make a public comment can make a public comment. Your time limit is 3 minutes per person. We will start with anybody who, sorry, before we do that, we need to take the roll. So I think our secretary is joining us from Carson City. Is that correct?
That's correct.
That's correct.
Okay, fantastic. Is that Ms. King?
Yes, it is. Hi.
Yes, it is.
Okay. For some reason, you're not showing up on the screen that I'm looking at, but it is okay. I think we can get through the roll without the video feed. So if you'd go ahead and call the roll, please.
Senator Harris.
Present.
Senator Pickard.
Present.
Assemblywoman Krasner.
Here, thank you.
Assemblywoman Marzola. Assemblywoman Nguyen.
Present, and Assemblywoman Marzola is also here. She forgot to press the speaker button.
Thank you. Assemblyman O'Neill.
Here.
Assemblywoman Summers Armstrong.
Present.
Chair Scheibel.
Here, thank you. And that is a good reminder, if you are speaking in person, when you come to the table, there's a little button you have to press to turn your mic on. That's how your comments get included in the record. Even if you speak really loud, you still have to hit the microphone button. And we also ask that you identify yourself every time you're speaking. Everything is being transcribed, so while we know right now who is speaking, when we go to read the minutes later, it is incredibly, incredibly helpful to our hardworking secretaries and staff to have you give your name at the very beginning of your comments every time you comment. And so we'll practice with some public comment. Is there anybody wishing to give public comment here in, I don't see anybody here in Las Vegas coming to the table. We'll go to in-person in Carson City. Maybe my colleagues up north could give me, oh, perfect. There's nobody in Carson City. And anybody on the phone?
Good morning, Chair. Your public line is open and working, and you have no callers at this time.
All right. Then that will allow us to get into the rest of the agenda. I'm going to go into just a brief 1-minute recess. And we're back. With that, we are ready to move on to agenda item number 3. We are making great time. This is the approval of the minutes from the April 8th meeting. And those are available online, by the way, if any of you are following along. They are a attachment or they're uploaded with the agenda as a agenda item. I would accept a motion to approve the minutes from the April 8th meeting.
So move.
We have a motion from Assemblywoman Nguyen. Is there a second?
Second.
There is a second from Senator Harris. All in favor say aye.
Aye.
Any opposed?
Aye.
All right, I don't hear any opposed, so by a unanimous vote of the committee, the minutes are approved from April 8th. And that will take us to agenda item number 4. Our fantastic policy analyst, Patrick Guinan, is going to give us a brief overview on some juvenile justice issues. He has served as staff on the Juvenile Justice subcommittee or committee in the interim for many years now. He's very knowledgeable on this subject, and so I've asked him just to sort of bring us all up to speed as we embark on Juvenile Justice Day here at the Joint Interims Committee.
Thanks, Chair Scheibel. This is Patrick Guinan. For the record, I appreciate the kind words. I just wanted to go very briefly for the members' benefit and the public's benefit this morning over a list of juvenile justice bills that were approved, all except for one of them, which I'll talk about in a minute, from last session. I've provided a list to the committee, and if you've got that list online, all the bills are hyperlinked so that you can go to the bill itself if you'd like to. And the bills that are highlighted on the list are those that were requested by the Child Welfare and Juvenile Justice Committee. The ones that are not highlighted were not. The purpose in listing these bills for you today and going through them briefly is because virtually all of them, I believe, will be spoken about at some point during today's meeting. And so I just wanted it to be convenient for everyone to have a list to go through so that when they're mentioned, if you want to look at them, you can. So I'm going to read through them and just do a little shorthand very briefly. I won't go into lengthy descriptions of the bills because I believe that's going to happen during the meeting today. And the experts in the room will be able to answer questions about those bills as well as our legal counsel should any come up. And I'm happy to answer questions when appropriate, but I'm not going to start by droning on about the bills for a long time. So just very briefly, last session, Assembly Bill 132 created an easily understandable Miranda warning that's required to be given to juveniles when they are arrested. Assembly Bill 158 reduced penalties for low-level drug and alcohol offenses for some adults and for minors. Assembly Bill 230 made changes to the process for certifying a juvenile to be tried as an adult. AB 251 makes changes to record sealing and expungement when a juvenile reaches the 18 years of age. Senate Bill 7 made changes to the jurisdiction over certain protection orders against minors. And I might say, I think that if any of these aren't going to be mentioned, it might be Senate Bill 7. It was more of a technical adjustment to jurisdiction in the courts, but it may come up, so I wanted to list it here. Oh, it's closer? Okay. Sorry. Is that better? So now we're on to the Juvenile Justice Committee bills from last session. Senate Bill 356 required a study of housing youth regionally in local facilities or DCFS facilities rather than farther away from their homes. And that study is ongoing, and there will be a report required later on in this interim that I just wanted to alert the committee to. Senate Bill 357 is related. And that requires the Department of Corrections to report on the cost of housing youth who have been tried as adults at the Lovelock Correctional Center. In the past, those costs had not been broken out within the budget, so the legislature asked for DOC to do that for us, and we should be receiving that information later on this interim as well. Senate Bill 365, which did not pass, sought to create a pilot program for housing youthful offenders elsewhere than Lovelock. Again, sort of a regional housing model. I do believe that's going to be discussed today at some point. Senate Bill 366 dealt with providing housing and services to juveniles that are deemed incompetent to go through the adjudication process. Senate Bill 385 asks for a report on the effectiveness of juvenile front-end diversion programs. I believe that's going to be mentioned through DCFS today, and it's a sort of a fiscal matter in terms of whether the funds that are being used well. So we probably will hear about that. Senate Bill 398 is the last one on the list, and it requires the Juvenile Justice Oversight Commission to submit to this committee an update to their 5-year plan. That deadline is later this year, and the JJOC was not able to attend today. The co-chairs are both busy and couldn't be here today, so we're intending to have them back in July, hopefully, and we may have some other juvenile justice matters come up again at the July meeting, just for those of you who are interested in marking that on your calendar. And that, Chair, is all I have for a bill update for juvenile justice, unless there are questions. Thanks.
Thank you so much. Do members of the committee have any questions about those bills? I'm not seeing any in Las Vegas, any in Carson City. I'm not hearing or seeing anybody, and any on online. All right, thank you so much, Mr. Guinan. That will take us to item number 5 on our agenda. This is a presentation on juvenile justice programs and updates on implementation of legislation from the Division of Child and Family Services at the Department of Health and Human Services. Thank you, welcome, and the floor is yours.
Good morning, Chair Scheibel and members of the committee. My name is Cindy Pitlock, and I serve as the administrator of the Division of Child and Family Services. I brought to you today my A team to give you a presentation, but I wanted to introduce myself and let you know that I will certainly be here all day for input, any questions, and to help steer my team. So I will turn it over to them, and good morning, everyone.
Good morning, Chair and committee members. I'm Dr. Jacqueline Wade, and I will be providing the part of the overview for you and my other teammates. Okay. We'll go over the mission of the Nevada Juvenile Justice System. And the mission is to enhance community safety by promoting positive change, positive life outcomes, and accountability for youth in our care and custody by investing in highly qualified team members. Our values is to provide safety, integrity, and a richness of diversity and create opportunities for youth. And our values is to provide a comprehensive array of services to our youth and families. Our goals, what is unique about the juvenile justice system in Nevada? We have chosen to keep juvenile justice system under the Department of Health and Human Services, Division of Child and Family Services. Nevada has always believed that youth and adults should be treated differently, and this is unique to Nevada. On the next slide, which is the funnel, it shows at the top of the funnel that if we provide services at the front end, this is the best place to intervene, and it is also a deterrent to going further down into state facilities. So if we do the front end, and our counties are doing a fantastic job of meeting the kids when they come into the system of providing deterrent services. So all counties are doing a fantastic job in that area. Next slide, you will see the youth level of services. This was adopted, the statute 62B.625. The state adopted this to determine the risk of placement and service provision for all youth coming into service. And if you look at the domains, it looks at education, attitudes, peers. And what this instrument does is the higher the youth scores on this instrument, it determines the length of stay, and it also sometimes determines the facility that they're going into. For example, males, the higher they are, would likely go to Summit View. And not always, but with the girls, because we have one facility that currently serve girls at this time, would go to Caliente. Next slide. We'll talk a little about the facilities within the state. Summit View Youth Center is our locked facility. It has 48 beds and currently has a census of 48. It serves our highest risk males, and that is the age up to 20. And the education is provided by Clark County School District. Programs within Summit View are positive behavior intervention and supports. Also, they use the YLS to determine services within the facility, and there are also lots of treatment and therapy and trades for the population. Next slide. Nevada Youth Training Center, which is in the north, it is staff secured and 64 beds, currently has a capacity of 64. It's medium risk for males up to 20 years old. What we're also looking at is seeing if we can add girls to that population so that we will have 2 facilities that are serving females in the state. The education is provided by Independence High School, and they also have programming for wrestling, and they're part of the work crews and vocational training. Next slide. Then there's Caliente Youth Center, has 112 beds, 7 cottages. It currently has 20 girls and 20 boys, and it's for lower risk males and females, and they also serve youth up to 20 years old. And the education is provided by Lincoln County, and they also have vocational training programs within that youth facility. Next slide. Mental health services are provided across all facilities, and based on the YLS, it determines services used and provided. Across all facilities, they receive therapy if needed, and also family therapy. So the focus is on the youth and their families and involvement. If there's a need for substance abuse, we also contract out services, specialized services, such as if they need juvenile sex offender treatment, and also dialectical behavior therapy. I'd like to look at our successes within the facilities. We are seeing a number of youths coming out with their high school equivalency tests. More youth are graduating with moral reasoning training across the facilities. They're 100% completed in their mandatory trainings for the facilities, and the hiring of direct line staff. We do have some challenges within our facilities, and the adequate placement for youth. Challenges such as managing youth with significant mental health issues, that is a challenge that we're facing. And then there's also a challenge in hiring specialized mental health staff. So there's a shortage in that area. And there are some delays with the prison rape elimination background checks. And there's also a lack of trades and programs such as welding and plumbing. And in the past, we've had youth that have gone through our facilities that were able to have access to these types of trainings and come out with a certificate and can go back to their communities and be of service with such specialization. Next, we have Chief Leidy, who will present the Youth Parole Bureau.
Good morning. Dave Leidy, Chief of the Youth Parole Bureau for the record. You were shown a slide of a funnel, and the Youth Parole Bureau is at the very deep end or the bottom part of that funnel when youth continue to move through the system and ultimately go through one of our correctional centers and they come out on parole. To give you an idea of what that means, of all the youth in every county that touch the juvenile justice system in the beginning, somewhere around 1.7% of those youth actually make it all the way down to the Youth Parole Bureau. So the counties, again, are doing outstanding job with front-end services. So the Youth Parole Bureau is made up of around 44 staff, and the map that you see is our locations. We have Clark County. Las Vegas is our biggest location. About 60 to 70% of our youth get committed out of Clark County. Our second largest is Reno or Washoe County. And then we have 2 rural offices, one in Elko, Nevada, and one in Fallon, Nevada. The Youth Parole Bureau is made up of 23 Category 2 peace officers. Their titles are youth parole counselors. We have 5 managers that manage those youth parole counselors and 5 mental health clinicians. We also are in charge of the Interstate Compact on Juveniles, and we have 1 specialist that works in that area, as well as an administrative assistant that helps that program. We have 1 social service specialist and 1 chief. Next slide is the Youth Parole Snapshot that was, there's a yearly one on the left, and that is to give you guys an idea of how many youth are committed monthly, and that is across, that is adding up all counties across the state. You can see it's pretty volatile. We never really know how many kids we're going to get in a month, somewhere down to 5 and upwards of 20 a month. So keeps us working pretty hard in some months, and some months are slower. There's a snapshot that of data that I took on April 19th that shows the first slide for males are in blue are the kids that are out, we call them street caseloads, but they're the youth that are out in the communities in Nevada. And then there's the bar right next to it, and those are the youth that are inside the institutions at the time. Our youth parole counselors, we count those because we start interacting with families and youth the day of commitment. And so they're starting to make relationships with the youth and the family. So those institutional cases, although they're in the institution, we still have them on the caseload of the youth parole counselors. An average caseload currently is about 17.2 youth per counselor. That's when we're fully staffed. We usually run about 2 parole counselors down, and so that raises that to 18 or 19. It's been my experience around 15 is a very manageable caseload. Anything above that, it gets a little tricky. When we get into 20 and 25, it gets almost undoable with the amount of staff that we have. Next slide. I wanted to talk a little bit about the commitment of a child and placement in a correctional facility. The NRS is stated there. That's how judges across the counties can commit youth. The first one is committed for correctional care, and the second part is when they're in need of mental or residential psychiatric services or other residential services. So this is how these youth enter the deep end of the system legally. Difference between criminogenic youth and from severe mental health youth. Dr. Wade gave a great presentation about our facilities. I wanted to mention that our facilities are not residential treatment facilities. They are not mental health based. They are correctional based. They really do a great job on helping with criminogenic factors and those issues. They do have mental health counselors there, and they do have some services there, but they are not for the acute mental health youth. So that's part of, later on in the presentation, a part of our struggles with that. We all know that criminogenic factors and mental health are always intertwined. There's not one or the other. They're always at some level intertwined. And we struggle with, does the mental health drive the criminogenic factors, or do the criminogenic factors drive the mental health? That's the struggle that we have of where to place children, where to get them services, and to best have better outcomes for our children. Next slide. Our youth parole successes and challenges. We implemented the youth level of service that you heard Dr. Wade talk about. That is a statewide, counties and state use that level of service to determine how often we see the youth. If they're intensive, if they're moderate, or they're or lower, we use that to see the youth in the communities, and we also use that to pick services. If you look at the youth level of service, there's criminogenic factors there. We take the top 3 and we really hit those really hard, whatever those are, so the case plans are individualized for each youth. They are not a cookie cutter type of case plan, so they're very individualized for the youth's behaviors. We also implemented the youth level of service case plan, which is attached to the YLS youth level of service. We completed all the peace officer standards and trainings, mandated trainings, as well as DCFS mandated trainings. I bring this up because as youth parole counselors and peace officers in the state, we have a huge training regime every year. I counted up my hours to keep my peace officer standards and training, as well as our DCFS training. It was well over 80 hours of training. So we have very competent counselors and officers working for us. We completed a transition to our new case management system called Tyler Supervision, which was not an easy task. Now it's not 100% complete, but now we're able to pull data and look at data that we've never had access to before, so that was pretty exciting for us. Our challenges is a lack of community programs for services in mental health. So we may have a youth who, let's say for instance, had a burglary, but we also know that that there's some mental health issues there. We can deal with the burglary by home visits and making sure that there's no tools and we can deal with that. What we struggle with are the challenges of where to get mental health services for the family and for the youth. We lack juvenile sex offender programs and services. We just lost one of our biggest programs in Washoe County. It was called Hand Up Homes. And so even though that may be a smaller number of youth, those are the important youth, and we lost a big program there, so we struggle with what to do with juvenile sex offenders. And the last challenge is the psychiatric services, who can provide assessments and who can do med management for families that we supervise. I do want to point out that our administration has heard these, and they have responded, and they have helped us out, and they've put in, as I understand this legislative session, have put in or asking for lots of money and lots of, they're on it. I wanted to make sure that this committee knew that. At this point, this concludes my presentation. And Leslie Biddleston, Social Service Chief 1, will be next.
Good morning, Madam Chair and members of the committee. My name is Leslie Biddleston. I'm Social Services Chief over the Juvenile Justice Programs Office within the Division of Child and Family Services. The Juvenile Justice Programs Office does not provide direct services. They are an administrative unit that is responsible for a variety of federal and state mandates. Some examples of federal and state mandates include compliance with the Juvenile Justice Delinquency Prevention Act, compliance with the Prison Rape Elimination Act, which are federal requirements, and various state requirements to include statewide gathering and collection of juvenile justice data from the time of referral, which is done in the counties, to time of discharge, which may be youth parole. This office also oversees various grant funding, both federal and state funding. In addition to federal and state mandates, the Juvenile Justice Programs Office supports DCFS direct services, which would be the 3 state correctional facilities and youth parole, by providing oversight over correct uses of corrective room restriction in facilities, use of force, staff training. We also conduct quality assurance reviews to ensure that our staff and facilities are adhering to policy. Another aspect of the Juvenile Justice Programs Office is we do support implementation of newly enacted bills. So I'm going to give a brief overview of some of the bills that this office has worked on over the last few months. The first bill is Senate Bill 108. Senate Bill 108 requires all juvenile justice practitioners in the field to be trained in cultural competency and implicit bias. It also requires DCFS to write regulations. DCFS does not have authority over all juvenile justice practitioners, so the regulations that were written were geared towards DCFS staff and county probation and detention staff. Those regulations have been drafted, 2 public workshops have been held, and those regulations have been provided to LCB for drafting. We are currently searching for a qualified vendor and expert to help develop training on the go forward, as this is a highly specialized field. Moving on to Senate Bill 356. Senate Bill 356 is a joint bill between the Division of Child and Family Services and the Department of Corrections to conduct a study on the housing of youthful offenders who are convicted as adults, and also, as you heard Mr. Guinan say a little bit ago, regionalization and keeping kids where they live. There was an appropriation tied to this bill of $50,000 to hire a vendor to gather the data and write the report for the division. A request for proposal is currently out in search of a vendor. That request is up on DCFS's website, and we are accepting applications until the 10th of May. So we are hoping to get a good qualified vendor to assist. SB 356 study components, ratio of juveniles versus ratio of staff to juveniles versus ratio to staff of adults. In juvenile facilities, we adhere to the PREA ratios of a 1:8. Adult facilities may be much higher than that, 1:20, 1:50, or maybe possibly even higher. Training requirements. There is quite a bit of training requirements for staff that work in juvenile facilities. As you heard Chief Liety say just a minute ago, there's quite a bit of training requirements for staffing in juvenile facilities. Another component is reviewing the age of majority. The age of majority is outlined in 62A 03.030 as 18. And up to 20 in certain circumstances. This study will also include looking at raising that age of majority to something higher than that. Additional requirements for juveniles in facilities is education, vocational training, and mental health services. So all of these things may add to costs of housing juveniles in juvenile facilities. Moving on to SB 385. SB 385 is a study of the use of prevention funds in Nevada. Prevention funds are front-end services and may also be referred to as diversions. Prevention services are provided within the counties. Those are where the front-end services occur. The half of the funnel on this page was taken from an earlier slide that Dr. Wade presented, just to indicate that front-end services are provided in the counties, and they do a fantastic job. There is a requirement that all prevention services must be evidence-based. Study components of SB 385 include looking at the percentage of diversions compared to referrals, looking at the types of programs and services that are currently provided by our counties as compared to what the national trend is, funding mechanisms, how are counties funding those front-end services, and the average cost per youth for diversion. Moving on to SB 398. SB 398 is a bill that requires the Juvenile Justice Oversight Commission to update their progress on their 5-year strategic plan. The strategic plan was a component of Assembly Bill 472, which passed in 2017. So a strategic plan was written by the Juvenile Justice Oversight Commission in 2018. So this bill is to provide an update on what the commission has done. SB 398, successes and challenges. The first success is the selection of a risk and needs assessment. You've heard both Dr. Wade and Chief Liety talk about the YLS. The YLS is that risk and needs assessment that was selected. The JJOC looked at 3 tools and selected the YLS. Staff were trained statewide in 2018 and began using that tool in roughly 2018. The JJOC also selected a quality assurance tool. The tool is called the Correctional Program Checklist. This tool assesses the quality of evidence-based programs and services provided within the 3 state correctional facilities and the 2 youth camps. There are currently 12 trained assessors on this tool. AB 472, which passed in 2017, also required the creation of an evidence-based resource center. The JJOC selected a vendor, and a resource center was created in roughly 2018. The last success was the establishment of an array of performance measures, which looks at the youth from referral to case closure and what is happening with those youth. The challenges of the JJOC and of DCFS include data sharing across county and state lines and across systems. As you know, children touch many systems, the education system, the court systems, and possibly even the child welfare system. So we have multiple systems that youth are touching. Measuring recidivism. Measuring recidivism can become difficult and is difficult as youth move through the systems from county to state and possibly even moving on into the adult criminal justice system. Program evaluation and outcomes is much like recidivism. As youth, it gets difficult to track youth as they move through programs and services and across county and state lines. And then the last thing is training. Chief Liety discussed the massive amount of training. So it's just making sure that our staff are keeping up and are current with training. And that concludes my presentation and the presentation of all of the DCFS staff. Myself, Chief Liety, and Dr. Wade are available for questions.
All right, thank you so much for your presentation and for that update. We'll move to questions from members of the committee, starting with anybody here in Las Vegas. I don't see any questions from the members here. Do we have questions from the members up in Carson City? Not seeing any. And how about from our committee members online? All right, they're both shaking their heads. I do have one question, and it was part of your presentation. I'm particularly interested in SB 108. It's a bill that I worked on closely last session, and I'm concerned that we're having trouble finding a vendor for that training program. And I'm wondering if there are parameters that are set in the administrative code or in the law that maybe I'm not familiar with about who would be a qualified vendor, or whether you're just speaking more generally, we're having trouble finding somebody who does this kind of training.
Thank you for the question. Leslie Biddleston for the record. There were no outlines of what is a qualified vendor within the bill, but it's more of a high level of looking to find somebody maybe associated with a university or an advocacy group who is familiar with that topic and gear it more towards our juvenile justice population. There's a lot of training out there for cultural competency and implicit bias, but very little training which is geared towards the juvenile justice field. So that's kind of what we are looking for.
Okay, thank you. I have a couple vendors in mind, so maybe we can chat afterwards, but I also just want to clarify, I'm sure that the department has particular qualifications that every vendor has to meet. I mean, do you only contract with firms or organizations? Do you contract with individuals? Do you contract with people out of state? What kinds of considerations go in from the administrative side?
Leslie Biddleston for the record. Part of the regulations that DCFS drafted addresses those very issues. However, when conducting or contracting with a vendor to provide any type of training, we do and have contracted with in-state and out-of-state vendors. It's really looking for that best fit for the actual training program or training topic.
Fantastic, thank you. One more. All right, we've inspired the questions. I'll start with Senator Pickard.
Thank you. Not really a question, just a comment. Having been in connection, particularly through my wife as a juvenile hearing master for quite a while, I just wanted to compliment you guys on how good a job you do. Our kids need the kind of services that you provide. I wish we could send more money your way to expand those services, but you guys do a great job.
Thank you for that. And Assemblymember Marzola.
I'll turn my mic on this time. I'm not sure who is able to answer this question. Earlier, it was stated that I believe in Reno, a program was lost relating to juvenile sex offender program, and I wanted to find out why.
Dave Leidy for the record. The program in Reno that was lost was called Hand Up Home. It was a juvenile sex offender specific program. Those are programs that are difficult to keep open because we just never know how many juvenile sex offenders we get. Sex offender treatment primarily is a year or longer. And so if I believe it was economics that had that program not be able to keep their doors open. I do know our administration, when we found out that they were closing their doors, we tried other avenues of trying to get them funding, and it just wasn't able to keep that open. So I believe it was a funding issue.
Thank you.
Welcome.
All right. I'm not seeing any other questions. Thank you again for, oh, there is one more question. Thank you. Assemblymember Summers Armstrong, go ahead.
Thank you, Chair. Can we just follow up a little bit further on that inquiry? And thank you, Assemblywoman Marzola, for asking, because I also had that written down. So without that program, what is the stopgap? What do you do now without a program like that in that area or in any area? If there's no outside program, what happens to the young people?
Dave Leidy for the record. We have one other program in Clark County, and then we look for out of state, which we don't like to do that. We don't like to send the kids out of state, especially in this demographic where part of their treatment is to reconcile with their family or their victims, and we can't do that from out of state, and it's very difficult to do from different cities. We do our best. We place youth in Clark County, and then we would go out of state to have them do that treatment.
Dr. Jacqueline Wade for the record. In those instances, we also have providers within the counties that are providing outpatient juvenile sex offender treatment. So we're able to augment services in that specialization.
Follow-up, Chair.
Yes, go ahead.
Thank you. Do you find, though, that the youth respond better and have less recidivism with an in-house treatment? And do you have quantifiable data that you could share with us later about how that works? Thank you.
Dr. Jacqueline Wade for the record. We could certainly find data. If we have it, we will provide it to you. But that is a good question regarding services in-house as opposed to going out. We also have services come into the facilities as well with contractors. So we have much of a hybrid approach to treatment when it comes to that specialization.
Dave Leidy for the record. I also want to point out that, again, with this demographic and with that sort of youth, it is very difficult to have that youth in their home while treatment is happening. A majority of the time, the victims are in the home, and it's not appropriate to have the victim and the perpetrator in the home at the same time while doing that. So, unfortunately, if there's not a program, we try. Not necessarily residential. We try like foster homes. We try any other home that we can keep the youth safe while they complete their treatment. So when we do lose a residential treatment place where there is a bed and a safety net, it's huge for us.
Thank you. Other follow-ups or additional questions? Okay, I'm not seeing any. I'll give them a sec. All right, thank you again for your presentation. We will move now to the next item on our agenda, which is item number 6. Our representatives from Washoe County and Clark County Department of Juvenile Services. And it looks like we have 2 people in Las Vegas. Are there other presenters elsewhere? Do you know?
Madam Chair, this is Liz Flores representing Washoe County Juvenile Services.
Aha, I thought that might be the case. All right, I'm not sure if you guys have already discussed who's going first. I'm just doing the slides. Okay. Or if you guys are presenting together.
This is Liz from Washoe County. I'm prepared. I think I'm first on the agenda, so I'm prepared if Clark County is okay with that.
All right, I'm getting the nod, so please go ahead.
Thank you. Thank you, Madam Chair and members of the committee. My name is Liz Flores, and I am the Director of the Washoe County Department of Juvenile Services. I want to express my thanks for allowing us to speak about Washoe County and the services that we provide to our community. We work out of the Jan Evans Juvenile Justice Center, and our mission is to help create a safer community by providing a continuum of services and sanctions to at-risk youth and their families. For those who don't know, I think most of you do, Jan Evans was a former assemblywoman who was a tremendous advocate on behalf of children in both the dependency and delinquency systems, and we're very honored that our building bears her name. We operate under the authority of Title V, which is Chapter 62 in the Nevada Revised Statute. Our administrative oversight is provided by the Honorable Judge Bridget Robb of the 2nd Judicial District Court. We have our organizational chart, which shows our administrative areas, as well as our detention center, which is called Wittenberg Hall, named after Helen Wittenberg, who was an advocate in the 1960s in our community. Probation services, community services, our traffic court, and clinical services. Those clinical services are dedicated primarily to the youth in our detention center. We have an operating budget of about $17 million. And I wanted to talk about our philosophical underpinning. We follow an approach called the balanced approach, and I've been in this business now I've entered my 28th year, and this is the philosophy that I was trained under. And it is very similar to the more recently known restorative justice model that I know was a major theme in this last legislative session, and a lot of the tenets of the restorative justice model have been incorporated in the school district as well. Our practice reflects the values that we place equally on community safety, victim restoration, accountability, and youth and family development. All of our practices and our policies support this holistic approach to managing youth and clients. This next slide provides context as to who we serve. Context. In Washoe County, our population is 485,000. Our school-age population is 61,000. Of those 61,000, about 38,000 are jurisdictionally eligible for our services, meaning that they fall between the ages of 10 and 18. In 2021, we had about 2,100 referrals, which is a very low number. This is much lower than our pre-pandemic referral numbers. We had 39 state commitments, 33 residential treatment center placements for children who require psychiatric care, and 14 county commitments or county placements. Our county camp is called the China Spring Youth Camp, Aurora Pines Youth Camp. That's a lower than normal number as well due to the boys program closure that occurred due to budget reductions. I'll speak more about that later. So here's the funnel again, the famous juvenile justice funnel. The reason we continue to use this funnel, and it has actually been presented probably over the last 10 years to this legislative body, because it is an excellent illustration of how youth enter our system and the various point of exits that are afforded them. I won't go into it a whole lot because it's really been explained, and I appreciate our state partners indicating that they recognize that there's a great diversionary effort that happens at the county level. Next is our department overview. So starting with our detention services, when law enforcement bring youth to our detention center after they've established probable cause, we then have to review our detention criteria, which are primarily risk of flight, risk to self, and risk to the community, and there are other categories as well. Our detention center is called Wittenberg Hall, and it opened in 2004. We have 108 beds. We have Washoe County School District teachers on site, food and nutrition services, mental health services, and we have programming within our facility as well. Our probation services, you can see how they're organized here. We have an informal supervision unit. That's the unit that is staffed by civilian case managers who provide assessment and intervention for all of our misdemeanor offenders. Then we have our probation assessment unit. That unit provides assessment for all of our felony, gross misdemeanor offenders, as well as our chronic misdemeanants who have been unable to benefit from the interventions that we've tried at the lower level, the top tier of the funnel. We have our compliance units, otherwise known as general supervision. We also have specialized probation units, including our sexual behavior unit, our gang unit. Our gang unit is part of the regional gang unit in our region. A behavioral health unit. We have officers dedicated to the youth who are placed at our local camp, and we have officers dedicated to our substance abuse caseload. We have a community services unit. Our staff teach many youth development programs, including basic skills. We have evidence-based programming, aggression replacement training, victim awareness program. We also work in conjunction with the Nevada State Police, who provide an excellent driver safety course. We have an evening reporting program that we're going on our 15th year of operation, where we work very closely with the Boys and Girls Club of the Truckee Meadows. Our staff pick up youth after school, take them to the Boys and Girls Club, where they were afforded opportunities for educational supports and pro-social learning, pro-social activities, and then we take them home in the early evenings. We know that that period of time is the time of day where youth are most likely to engage in delinquent behaviors. We find tremendous success with this program. Bless you. We also operate a work program. We work, our youth on our work program are assigned to local county parks, as well as we have a partnership with the Truckee Meadows Water Authority, where youth also work in those sites. We have a youth employment program where youth are able to earn income after they learn basic skills and basic employment skills. And again, we do that in conjunction with the Washoe County Parks and Tumwa. I failed to mention that another partnership with our work program is with the Reno Sparks Convention Authority, or the Livestock Event Center. We also have a restitution program. We have a victim services coordinator who collects restitution on behalf of our victims in our community, and she also helps our victims navigate the court process. In juvenile justice, we have a couple metrics that we use to try to measure how it is we are doing. What are our outcomes? And one of those is our diversion rates, which we've talked about before. In 2021, we had a 74% diversion rate. 23% of our youth ended up on some sort of court supervision, whether it be formal adjudication or supervision and consent. And then you can see that 3% that fell in the deepest part of our funnel with state commitments and adult certifications. Another measurement we use is recidivism. This is just a snapshot of one of the things that we track. One of the things we track are the reoffense rates for juveniles over a 2-year period of time. So you can see this one, for example, for youth that were placed on supervision in 2019, when we tracked them for 24 months, 82% had 0 rearrest, 14% had 1, 3% had 2 rearrests, and then 1% had 3 or more. And this was for felony and gross misdemeanor offenses. We're proud of this number. We continue to challenge ourselves to improve these rates. One thing of note before I move on is that while we look at diversion rates and we look at recidivism rates, there's another metric that we're exploring a concept, and it's called desistance. Actually, there's a training that we brought in. It started yesterday and is ongoing today, called Growth-Focused Case Management. And part of the concept is around desistance, which is an attempt to measure the gradual ceasing of problematic behaviors. And it's difficult to do that, but some of the metrics include things around well-being, stable housing, employment, education, healthy relationships. So this is something we're exploring in Washoe County to measure how it is children are decreasing those behaviors. So I hope to report more on that at a different time. We also monitor trends. We are data analysts in all of our juvenile justice agencies. And this was always an interesting one to refer to. There is an error. It's a 15-year snapshot. It's not from 2010 to 2021. It's actually from 2007. But nationally, as well as locally, juvenile crime has subsided. We did see in 2019 an uptick, and actually the first 2 months of 2020 we saw increased rates of referrals. However, the pandemic hit in March and our referrals dropped by half. In 2021 we did see an increase, so we will continue to monitor these trends. Just to segue into a separate area, just as a matter of interest, even though we've seen decreasing delinquency rates across the country, we have seen, sadly, an increase in suicide over the same period of time for teens and young adults. We track regularly our average daily population in our detention center, as well as our average length of stay And another measurement is the average length of stay of youth who stay over 3 days. That 3-day mark is when youth go to a delinquency hearing by statute. That has to happen within 72 hours. So you can see the length of stay when we look at it broadly from the time a youth enters our detention center to the time they leave. Those numbers are in the teens. But when we look at those who are detained after a court hearing, it goes up beyond a month. Another thing to note, one of the reasons we look at these numbers is that juvenile halls, by statute, are designed to be short-term housing facilities pending the disposition of a case. They are not architecturally or programmatically designed to be long-term housing facilities. In 2004, we were selected by the Annie E. Casey Foundation to be a JDAI site, which is Juvenile Detention Alternatives Initiative. And part of that process was to eliminate the overuse of detention. And for that reason, we closely monitor our statistics around the length of time children are staying in our facility. This is a look at our placements. Our residential placements on the left show residential treatment centers, so youth who are sent to treatment centers who are requiring psychiatric care. You can see a general decline in these numbers. In 2021, we had 25 in-state placements and 8 out-of-state placements. For our state and county commitments, again, generally declining. In 2021, we had 39 state commitments and 14 county placements. Again, that 14 is not representative of a normal year. The camp had closed their boys program for part of the year. It is now since reopened. Other trends that we monitor, and hopefully these just stay a trend and do not stabilize, but we've seen an increase in serious crime, gang shootings, violent gang activity, significant increase in firearm offenses. Unfortunately, we've seen increase fentanyl use, which has resulted in drug overdoses and death. In 2021, we had 8 overdoses, and 3 of those youth succumbed to that overdose and died. We've had the mental health component has been shared at length by our DCFS partners. That does impact us in our local facilities as well and in our local communities. We've seen a reduced access to acute psychiatric care and residential treatment center beds. And it was mentioned that the local sex offender program closed. And I support Chief Leidy's assessment of how that occurred. We also worked very closely with that vendor in northern Nevada to assist them in keeping their doors open. Economics was a driving force of that. The good news is there was a significant reduction in the number of youth who required that level of care for sex offender treatment. The bad news, though, is that it makes it difficult to sustain funding to provide that intervention. That vendor, Hand Up Homes, was a fantastic partner, and their rates of success were in the 80th and 90th percentiles. So another question had been asked previously about what is happening with these youth. And to support Chief Leidy's assessment, we did have a case that unfortunately we had to send out of state, and we are looking at our local providers to provide that support. The challenge is specifically around the youth who cannot return home due to the fact that victims remain in the home. A very brief update on legislative updates because that has been largely covered as well. We are in compliance. We have either institutionalized or are continuing to institutionalize all of the reform efforts that took place with AB 472, the juvenile justice reform, and all of these reforms we have instituted a lot of the changes in our policy and in our practices. Some of the training was regarding implicit bias, cultural competency, and for peace officers, crisis intervention. So we are working with all of our partners to ensure that we are in compliance with these requirements. Regarding the juvenile justice studies, prevention activities in the housing of youthful offenders, we continue to be partners at the table in those discussions. Challenges that we are currently facing. So this is just a snapshot of the number of evaluations that we do on average every year in our detention center. This does not include the ones that we do for children who are out of custody, but we conduct a lot of evaluations for our youth. AB 472, one of its requirements was to institute a mental health screening tool for youth who were not in custody. And so you can see in our juvenile justice funnel that at the very top, assessment is a piece of that. So we are identifying in juvenile justice a lot of the needs that our youth are presenting, not the least of which is the mental health needs, which are increasing at an alarming rate. So we've taken many efforts at the in the juvenile justice system to identify the youth. The problem is what we do after that. Within our detention centers, on any given day, approximately 60% of our youth are suffering from mental health diagnoses, and a significant number are prescribed psychotropic medications. Our juvenile services act as a mental health agency by brokering assessments, navigating the placement process, case managing treatment, and we are housing youth awaiting treatment. The primary barriers include lack of quality residential beds for both acute and long-term care, and Medicaid reimbursement rate for providers. Unfortunately, recent events have demonstrated that our out-of-state placements are denying Nevada youth treatment due to the low medication or Medicaid reimbursement rate. So the byproduct of that is that we have youth remaining longer in our short-term facilities, in our detention centers, waiting for mental health treatment. Another challenge we're facing is regarding our China Spring Youth Camp. Due to reductions of state funds to the camp, they had to shut down their boys program for a period of time, which did result, unfortunately, in an increase of our state commitments. The boys program is now back online. A proposal had been made by the 16 user counties in conjunction with NACO to stagger the reduction over 3 years, and that was accepted. The immediate impact was reduced capacity at the camp, and the current status is that the camp has made a lot of adjustments and improvements in gaining compliance with juvenile justice reform efforts that took place in 2017. They've done a lot of restructuring with staff training and reclassification of staff, and we continue to work with the camp closely to support their success. I'll end on the note that we talked about the juvenile justice funnel and how it is that we want to provide interventions at the earliest point possible to minimize the number of youth who fall deeper into the system. Nevada has a system of care on the mental health side that has similar concept where they attempt to do assessments at the earliest point possible, determine what level of intervention is required, and start treating youth earlier on during their mental health needs. What we're finding is that if there are interruptions in both the corrections funnel as well as the mental health funnel, these youth are staying longer in our detention centers. So those are the challenges that we are currently facing. With that, I will end my presentation, and I would like to again thank you for your time. And also I would like to extend an invitation to every member of this committee to come tour our facility. Thank you for your time, and I'm available for questions.
Thank you so much. Are there questions from members of the committee up here in Las Vegas? All right, I'm not seeing any, so we'll move next to our members in we will go next to Assemblymember Kresner.
Thank you, Chair. Appreciate that. And thank you, Ms. Flores, for your presentation. And thank you for the excellent work that you do on behalf of the juveniles in the state of Nevada. During the 2021 legislative session, I sponsored a bill with many co-sponsors of both parties, Assembly Bill 251, and that regards juvenile sealing of records at age 18. The prior law was automatic sealing of juvenile records at age 21. And this bill, Assembly Bill 251, changed it to automatic sealing of records at age 18 in order to give our kids a second chance because studies overwhelmingly show that if we are going to reform and help people to become productive members of society, our best chance of doing that is when they're juveniles. So this bill gives kids a second chance by automatic sealing of records at age 18. And I'm wondering if you can tell me if that has been implemented in Washoe County and if that has been implemented across the state of Nevada. And if you can't tell me, I'm hoping you can direct me to somebody that can give this committee that information, because I know it's important to every member of this committee because that bill passed unanimously in both the Senate and Assembly. Thank you.
Liz Flores, for the record, thank you for the question, Assemblymember Krasner. I am not the best suited to answer this question. I know in Washoe County, our courts and our agency, the District Attorney's Office and the Public Defender's Office have been working on this, and I believe it is part of the presentation of coming up soon by the DA's office.
Thank you.
Assemblywoman Krasner, I can answer that question a little bit more robustly. So in Clark County, we've been working with the Tyler technology to have an automated feature in the system, especially since our county's so big. So the problem with the system right now is when you press the button, it doesn't delete certain misdemeanors. So if a charge is reduced from a felony to a misdemeanor, it's not reducing that charge, but all the other ones are being automatically sealed, so we can't use that feature yet. So I'm being told in the next week or two that the system should be fixed. For the first time, we've never had that option before, but in Clark County, we're doing it manually. We started at age 21 and worked our way backwards. So we're going. We did all the 21-year-olds, all the 20-year-olds, and now we're working on the 19-year-olds. But once that is in place in the system, the other counties in the state should be able, because the majority of us, not all of us, but the majority of us have that in Tyler Tech, so it'll be an automatic sealing for the system.
And if we could just get your name for the record, please.
I apologize, Michael Wheelahan.
Chair, if I can follow up. Thank you, Mr. Wheelahan. Tyler technology, how do we ensure that this is being shared by all juvenile agencies, district attorneys, public defenders, and juvenile courts across the state of Nevada? Because obviously that's what needs to be done. The whole reason for this bill was because kids were not being able to get jobs because of a misdemeanor, maybe drinking a beer when they were 17, being arrested, cited for a misdemeanor, and then having that on their record for the rest of their life. They weren't being able to get jobs because this was coming up. They weren't being able to get into college. They were not being able to get scholarship money. So I know the entire legislature, both parties unanimously passed this bill because we all believe that kids should have a second chance. And so it seems like there's a little roadblock, and I know it's not your fault, but it seems like there's a roadblock here of getting this technology implemented across the entire state of Nevada. And I appreciate that Clark County's doing it. And I think it's just so important that we as a society invest in our youth and try to do everything we can to rehabilitate our youth so that they can be productive members of society. Thank you.
Michael Wheelahan for the record. So Leslie Biddleston mentioned earlier there's a statewide system that was required by AB 472. It's called Caseload Pro, and Tyler Technologies actually bought them out. So it's a Tyler Technology system. So not every county's up and running yet, but the majority of the counties are. And once that feature is finalized, all those counties should be able to request that from Tyler Technologies and put it in their systems. And Washoe County will be doing a presentation on their end from their DA and during their presentation.
All right, thank you. Are there other questions from our members in Carson City? It doesn't look like anybody is moving to ask a question, so I'll just open it up one more time to our whole committee, and I don't see anybody. So thank you so much, Ms. Flores, for your presentation, and we will move on to our next presenter.
Michael Wheelahan for the record. I'm the Assistant Director of Juvenile Justice. I've worked for the department for over 27 years. But one of the things I'd like to bring up now that we're having these conversations, where data is one of the priorities in the state, and that's one of the laws that have passed recently, and that's why we have the Tyler technology. We're trying to get it up and running, like Ms. Biddleton said earlier. But for Clark County, if you go on the county website, Clark County website, and you go down to the Juvenile Justice Department, we actually have a data book that goes back several years. It's a very robust data analyzed with crimes and race, gender, age, zip codes. It has a lot of stuff in there. So if you get an opportunity, I would suggest getting on there. It's and we're going to make it better. So everything can be improved. And then there's a group, it's called NAJA. So the Nevada Administrators of Juvenile Justice Administrators. So a lot of the things that we talk about between the state, Washoe County, Clark, all the other counties, we meet monthly and discuss a lot of these issues. So a lot of the things that Washoe and Clark counties are today will be the same for the other counties, because we share a common goal, and that's to rehabilitate children and meet the state law requirements. So getting to the last year's legislative session. So I just want to give you guys a brief update, because it was very important. A lot of people had bills that were passed, and you guys want to make sure that they were completed. The Department of Juvenile Justice tracked 40 bills, tracked more than 40 bills, but in the end, 40 bills directly impacted the Department of Juvenile Justice. So AB 132, which is the Miranda warning, was implemented within a week of it becoming state law. AB 158, the DA, the Harbor, and myself, and Bridget is going to testify more to that a little bit in her presentation. So that's already been enacted. AB 230, Bridget actually has some data, and that's been enacted with the DA and Juvenile Justice. So we've already got that in place, and she's got some data in her slide on that. And then as far as SB 07, that's more of a court function. But in our Tyler technologies, we're waiting on a feature so we can track it and give some data on it. So even though we're not the warehouser and the issuer of the protective order, but we can be a data function for it. So we're working on that. And then SB 108, some of the trainings that were part of the SB 108, Juvenile Justice has been doing for a few years. We have a training that we've done called 24/7 as a 3-day training that does a lot of the implicit bias. We already do cultural awareness, and they've both been approved by the post. As Mr. Lighty said earlier, we're peace officers, and so what we did do was we contracted a vendor from Denver, because there were some elements added to the cultural wellness that we didn't have. It talked about socioeconomic impact, the history, and some of those things of that nature that weren't in ours. So we contracted with a gentleman from Denver that had got the Denver PD out of a DOJ investigation. So he actually is a police officer there. He owns his own company. So it was recognized by the DOJ, by the state of Colorado, and Nevada Post has recognized our trainings too. So we are currently just waiting on the lesson plan for the trainings that were in SB 108, and those will be implemented before the year's out. So in the next, I'm guessing in the next month or two, we should be able to roll those trainings out to the Department of Juvenile Justice. So I can work with the state and provide some of this information, and then because some of it is more based on your geographic location and your clients and some of those things that you got to recognize the differences of the people that you work with, right? So we'll provide some of that to the state. Now, getting to the PowerPoint, I just was giving you like a basic overview of what juvenile justice, the difference between adult and juvenile. So I'm going to roll through this slide. This is usually like a 2 to 3 hour training, but I want you guys to understand the difference, and we're talking to juveniles and adults. So, and then in the end, I'll give you some of the diversion data when you're talking our truancy prevention outreach program and our harbor. So one of the differences between the juvenile and adult system is we share the common goal of safety and restoration towards the victim. With the juvenile system, our goal is to help young people avoid future delinquency and mature into law-abiding adults. So that's one of the differences, is we're trying to prevent them from going to the prison system. Obviously, with the prison system, it's too late. So not that they can't be rehabilitated, but we're trying to get to the point to where they don't even get to there. So one of the biggest interventions to reduce criminal activity is a pro-social adult relationship. So that's one of the things we're focused on. And one of our goals in the Department of Juvenile Justice over the last 2 years is family engagement. And we focus so much on just focusing on what the kids need. You got to realize that the whole family unit, if you send the child back and there's no services for the siblings or the parents, they're going to fail. And that's why the data hasn't been as successful as it has been over the last few years. So the way that they enter the system is through the referral process. So it's either an arrest or a citation that comes into the juvenile justice system. It can be through the school district, the police, or juvenile justice itself, or other law enforcement agencies. So the intake or diversion process. So they come into our intake unit. That would be our probation intake. And the DA would work with our probation officers to determine whether this can be formally processed through juvenile court or can be diverted informally or dismissed. So the DA and the harbor, we divert a lot of those cases through so they don't get the misdemeanors and some of the things like Assemblywoman Krasner was saying earlier, because we agree that some of these lower level charges that aren't historically violent or the self-harming behaviors, those could be dealt with informally by getting them the services and counseling, the mental health treatment that they need. So we also have trial by peers, community service. We hold open cases. So on a hold open, you would give some certain guidelines for the kid, and if he meets the conditions, then the charge is gone. So it won't be on their record. And then we also do restitution only cases. Sometimes it could be something small like breaking a window or something like that, which would be a misdemeanor. So we don't want to give them a formal misdemeanor charge. So if they can work off that restitution, make the victim whole, then it won't be on their record as well. And we also do informal probation in diversion court. So how does the kid get to the juvenile from the juvenile justice system to the adult system is two different ways. So it's either a direct certification, meaning based on the current laws, which some laws changed this last session, so there's a lot less charges that kids are direct filed on now. And Bridget's going to have some stuff on her slide to go over some of the changes with the numbers. And then there's the indirect, where based on the DA's recommendations and the judge making a decision based on the totality of the circumstances and the charges and the victim, then they would go through that process. Then we have our detention cases. So we have a juvenile detention facility, and they would be brought to our detention facility, and the intake would do a risk analysis based on the charges, age, and some of the factors, and then we would determine if they were a threat to themselves or the community. If not, that's where that informal process could be. They could be diverted, or they could be released home on a GPS if they're not a threat or severe threat to the community, or they could be just released home to their parents with some conditions where they return to court. So we have home management, and we also have kids that come into juvenile detention from a failed placement, and sometimes the placement we'd be willing to take them back. Sometimes it's just they need to get in front of the judge and get some counseling set up, and then they can go back. So there's an array of services that happen when the kid comes into detention. But if a kid's detained, so what they would do was they would have a court case, court scheduled within the next 24 to 48 hours. So except for weekends and holidays, it could be 2 to 3 days, especially on that Thanksgiving holiday where it's a little bit longer. But so they get to go to court immediately. The judge makes a decision whether they need to go through the formal court process or not at that point. So then they would go to a plea hearing where they would plea if they were innocent or guilty. And then at that point, if they pled guilty, that oftentimes there's plea deals made. So between the DA, the PD, and the youth and their family on what conditions would be met on probation, or maybe not even probation. And then at that point, if they're found, if they plead not guilty, they would go to a contested hearing, which is like a trial for an adult. So it'd be the same thing. So they'd go through a trial, they present the evidence and go through the court process, and then the judge would make a decision. And then later they would go to, they could get a consent decree, a lesser charge, or they might be placed at another institution. And then if they were found guilty, they would go to disposition hearing. So as an adult, it'd be called a sentencing hearing. So at that point, they would go to the sentencing hearing, and then they could be sent to one of our regional facilities. They could be sent to Spring Mountain Youth Camp. mental health placement. They could be released home. They could be put on a GPS. There's a litany of places. Even if they're found guilty, doesn't mean they're going to be locked up. And then they would also they could be certified as an adult. So 90% of youth adjudicated delinquents are sent either to community supervision, better known as probation. So the majority of the kids, even when they're found guilty, 90% of them are on probation. And they would have court orders that would get the mental health placement. It could be putting them on Medicaid. There's many things that could take place because what we're trying to do is restore the family and make them whole. And that's been the goal of probation, like I said earlier, to keep them out of the prison system. So, and they would get mandatory treatment and other court orders. The YLS, Mr. Leidy mentioned that earlier, is that was ordered by this legislation in, I believe 2017. It was AB 472. So the YLS is in place. It's called the Youth Level Service. It's a comprehensive risk and needs assessment. So the judge doesn't have to take that, but the judge normally takes that into consideration because it's a very robust. It takes about a week to 2 weeks to complete the report. So it's very robust, and it takes some of the bias out of the decision making because it actually has a calculated formula. You submit it into the system, and it gives you the very high, medium, or low risk, and based on that, there's a matrix on the potential what you can recommend for a kid as far as for our probation officers. Obviously, the judge can make a decision based on their facts in front of them, but for us, it's trying to take that implicit or explicit bias out of the decision-making process. So diversions have better outcomes. And I'll go over some of the data a little bit more when we get into the harbor slide. For non-violent minor cases, we try to divert as many cases as possible. And that's been with working with the district attorney and the judge. So it's been a collaboration of numerous agencies to work on this. So the history of juvenile justice has been their over-reliance on confinement of young kids. And oftentimes those kids don't look like me. Right? So, and I'll go over a little bit more of the data on that on a future slide. So we're trying to be more, and that this is the whole state. So trying to use more risk and needs assessments. We use a MAZI for a mental health screening. We use a UNLV pre-screen at our intake. So like I said, it's not, hey, I've been a PO for 27 years, so I think this kid should be locked up. So we've gotten away from that. So we're trying to use more data-driven, best practice approaches to making decisions at those points, right? So, and that's been a lot of the legislative things. One of the goals is to have better outcomes for these children. So, and juvenile justice agrees with that. So when we're talking nationally throughout the United States, 15% of the youth are black. 35% of the youth refer to juvenile courts. 35% are black, but the actual community is 15. So that's twice as likely as a black child to be referred to the juvenile justice system. 42% of the commitments in this, not just the state, nationally committed are youth of color, black youth. 42% when you're talking 15%. So when I'm talking, there's been an over-reliance of commitments to facilities. That's why we do the harbor and some of these other things to divert kids out of the system to try to get them to the point to where we don't get to that decision process where they're having to be placed in a facility. And as we know, youth's brains don't fully develop between the ages of 21 to 24. So, and then when you compound it by the influence of alcohol, trauma, physical abuse, and poverty, that increases some of the likelihood that they will engage in this type of activity. And most youth will just grow out of it naturally on their own. Minor delinquency is considered normal behavior for children. I'm talking minor delinquency. I'm not talking, felonies and things like that. I'm talking small, as a child, you get in a fist fight with your friend. Now would be considered an affray, right? When we were young, it was not, right? We didn't get arrested for an affray. So now we arrest people. So we've recognized a lot of that. We've worked with the school district and the DA, and that's why the harbor is in place, is for some of these. Now, the truly violent, where you attack a teacher, you attack a staff, you attack another student, that is not what I'm talking about. Those would be violent charges. So, and we're always trying to keep the community safety in mind. So that's one of our priorities, to keep everyone safe. Family engagement and cognitive behavioral approaches and programs are shown statistically to be more effective with juveniles. So in incentivizing positive behavior, we're pretty good as a system as creating punishments, but we don't reward positive behavior. And any teacher, psychologist, or any program that's very productive is going to have some positive rewards for kids after. There's going to be consequences for negative behaviors, but what do you do afterwards? You try to get some positive rewards, recognitions. It's not always money, right? It can be a certificate. You'd be surprised what some of these kids, when you put a certificate in their hand, how excited they are, because it's about completing something they're not used to completing. So the mission of the Harbor is to be responsive to the well-being of youth, families, and victims by providing meaningful services to improve connectedness to the community through academic achievement, reducing truancy, and providing a safe place for guidance. So the services provided there's many, but the main ones are tutoring, truancy prevention, mentoring, counseling, food, clothing assistance, and distance learning. So if you're talking about a child, bless you, if you're talking about a child that can't see the chalkboard and he sits in the back of the classroom, we're not in chalkboard anymore, I'm old. So when I was in school, it was a chalkboard. So now, a kid sits in the back because he can't see the board. But as a teacher, you don't know that, and you'll start labeling the kid like, well, the kid's sitting in the back because he doesn't want to learn. But really, the kid can't afford glasses oftentimes, or he's got abscessed tooth because they don't have access to medical care. So those are some of the things that the Harbor works on, is getting the family the resources to deal with some of these generational issues when you're talking poverty with our youth, right? And it's for the whole family. It's just not for the kid. So 70% of the total cases for DJJS, not the ones at the Harbor, but 70% were nonviolent. Okay? So the majority of our cases that probation deals with are nonviolent. Okay? And Bridget's going to have some really good data on the top 10 offenses that she refers or files on. So, and that's because of the Harbor has taken those smaller level cases, so we can focus more on the high end community risk, or the kid has self-harming, or self-harming behavior can just be the fact that you're committing crimes, right? So we can focus on that more than dealing with a kid that stole some shoes from Walmart because he doesn't have shoes for school. So we can work at some of those. So it's a collaboration of many partners. I'm not going to list them all because it's on your slide, but it's Juvenile Justice, Department of Family Services, the DA, Eagle Quest, and a litany of others, and other law enforcement agencies that will take the kids and drop them off at the Harbor instead of bringing them to our intake where they'd be formally processed and charged. So if they don't complete, I know that's a big thing. People are like, oh, they just don't disappear, and we're not like, oh, they're done. So if they don't complete, they're given 60 days. If they don't complete it, they're either we're actually working on a new process. So they're referred back to intake. So we just met yesterday, and what we're going to do is we're going to divert those kids to diversion court. So we're working on a process. So a lot of times it's family means you don't have transportation. Your family can't take off of work, because if you take off of work, you're going to lose the $200 you make. And if you don't get that $200, you're going to be kicked out of your house. You can't feed your children. So we're trying to be more understanding. We've done a lot more with technology. I guess the one thing you can say about COVID that's been a blessing to us in the juvenile justice system is actually being able to hold meetings live. So some of the families can actually attend counseling and things of that nature instead of having to get on the bus, take their 4 or 5 kids with them, miss work. So now we can do it more on, conveniently for families, so they don't have to lose it. So the Harbor opened in October of 2016. So we've had 20,050 referrals. 90% of them have not been sent back to probation intake. That means 2,198 were sent to intake. But out of those 2,198, don't be like, oh, they all, got incarcerated, or they got, something like that. No, a lot of them will actually go through an informal process through our intake to get them the counseling, the services and stuff. Like I said, sometimes the parents sometimes it's just a formality. Like one of the reasons we're doing diversion court is to sit in front of a judge. Oftentimes, just sitting in front of a judge makes it seem a little bit more serious. I need to do it, right? So that's part of the things with this too. So, and the 90% success rate, meaning they're not going to probation. Okay, so we also run another program called the Truancy Prevention Outreach Program. It's another diversion program to help the school district with chronic truancy. Obviously, for historical purposes, truancy actually used to be, they could be charged with it, kids were held in detention. Laws have been passed since then to keep them out. So, but we all know that truancy leads to being expelled. Being expelled means to making less money, and that's the school to prison pipeline, right? So what we've done is we've created this new program to try to get these kids re-engaged in school so they don't drop out, so they can graduate, so they can not be part of that pipeline, right? So the program launched in October of 2020. There was 27 pilot schools. Since its inception, there's been 226 schools are now participating, 6,968 referrals. It's similar services offered by the Harbor as well, except you add, Harbor does IEPs too, which is an individualized education program, which the school district does for kids that, struggle with have some learning disabilities or some mental health issues, right? So they'll get some specialized education. So oftentimes kids don't know they need that, or parents don't know that resources even exist. So once you get that kid in there, they can get the help they need to get back on track in school. So the major collaboration is between Boys Town, Department of Family Service, Social Service, and the school district. So we actually started seeing kids in January of 2021. COVID has obviously been an issue for us. I'm sure these numbers would be higher, but the school was not in session for quite some time, as we all know. So when you're looking at the success so far, and this has only been a little over a year, so I mean, this isn't like, oh, this is we're looking at the data, but when you're looking at after 60% of the interventions, kids attended school 6.5 more days for each quarter. That means they're not getting kicked out, right? And that's the whole point of it. Out of the 77%, the top 10 of those attended school 27 more days. So when you're talking education, when you miss, you get behind, right? So, and if you don't go, eventually you're going to get kicked out. So it's been very successful so far. If any of you would like to take a tour of the Harbor, I have my email and my office number on the slide, so you feel free and call me, and I'll arrange a tour of either one of those programs if you'd like. And just as a comment for the GSOs in Clark County, we have a little bit more resources here in Clark County, so we have group homes. So we're not having those issues because our providers are still providing services. So, and then in the future, in the next few months, we're going to be opening up a girls program, because that was mentioned earlier by the state, is we're looking for girls programs. So the Department of Juvenile Justice is opening a halfway house to try to divert some of these girls from the Caliente Youth Center, which is the only facility that houses girls. So if there's any other questions, thank you for your time.
Thank you so much for your presentation. Are there questions from members of the committee? Senator Pickard.
Thank you, Madam Chair, and thank you for being here. As you know, I've been a proponent of the Harbor, brought a bill last session to try to expand it into the schools. Didn't get a hearing, but it's an important effort. Can you tell me how the Harbor is doing under the current, in terms of number of people that they're able to help, and those that are turned away because there aren't resources available?
Michael Wheelahan for the record. Thank you for the question, Senator Pickard. So we don't turn anyone away. So we've expanded the Harbor. Originally it was at our Juvenile Detention Center, and now we have 5. And we're getting ready to expand it to a mobile Harbor. So it'll be like a RV bus. We're working on that right now, and then we'll be able to take it to the rural sections of Clark County, because that's where we're kind of failing in our services, is reaching out to Mawapa, Laughlin, some of those other places. And then when we're having issues in the school, we can take that Harbor, and when they're having severe issues, and maybe we can go there and try to get some of these kids services. A lot of times the behaviors because of things that are going on in the home. So for us, that mobile Harbor is going to be a huge step for us.
All right, thank you for that. And how are you able to meet that need or meet the demand? How are you able to expand if we don't have additional funds? Are we getting outside sources? Are there contributions being made? How are we meeting that demand?
the city of Henderson and North Las Vegas have allowed us to use buildings like in kind donations, so to speak. So we've had those, and then the county has pretty much funded the majority of it since the legislation didn't pass. But funding is a big issue for us right now for the harbors.
And if you could just put your name on the record. Sorry.
I apologize, Michael Whelan.
All right, thank you.
Other questions from members here? Questions from members in Carson City? I'm not seeing any, or any questions from our members online. All right. I think that concludes our questions for you. Thank you so much for your presentation. That concludes agenda item number 6. Yes. And so we will move on to agenda item number 7, presentations from the district attorney's offices. And I will let you guys, actually, looks like we have Washoe and Clark with us. I see Ms. Duffy here from Clark in Clark County. And is somebody from Washoe County up in Carson City? Yes, and somebody from Carson City. Somebody from Washoe County is in Carson City. I will let you guys tell us how you're going to present.
Good morning, Madam Chair.
Morning, Chair Scheibel. See how confusing it is? This is Bridget Duffy for the record. We did a co-slide, and so it'll flow with Clark County going first and then Washoe County picking up in the middle of the presentation. Good morning, Shelley.
Good morning. Good morning, Bridget. Shelley Scott, Chief Deputy District Attorney. I'll be appearing for the District Attorney's Office in Washoe County.
Chair Scheibel, thank you, and members of the committee. I'm just going to go ahead and start. I have already introduced myself. Our first slide is really an overview of the juvenile delinquency court process. And Chief Scott made this slide, and I realized I need to put it at the front because I think it's important for the community to understand how cases even get to the district attorney's office. I've learned a lot through 20 some years. And one thing I learned this year is that the community doesn't really understand that the DA's office doesn't just take cases and file cases. They come to us through a process. And in juvenile justice, it's even different than criminal justice in that in both Washoe and in Clark, the cases start with the juvenile probation department. And I'll make sure Chief Scott is able to talk about her county. But in Clark County, if a law enforcement officer cites or arrests a child, that all of those cases are funneled through to the probation department. By statute, the probation department has the right to divert misdemeanors completely and totally away from the district attorney's eye or view or determination at all. And that we use in Clark, we use diversionary services, we use probation intake, or which you've heard that phrase a few times now this morning, or probation officers for an informal process. On gross misdemeanors or felonies, the probation department are, for the most part, in Clark, the first to see those. We do have direct submissions from law enforcement agencies to the DA's office if it's not a probable cause arrest. So they would first be seen by the probation department, and then by statute, they would come to the DA's office unless we determine to reduce them and refer them back to a diversionary or an informal process. So I got a lot of calls as school violence was increasing about, what is the DA's office doing with these fight charges, and batteries are misdemeanors. So I had to explain to a lot of the public that I don't even have a case, because those misdemeanor battery cases go through a probation office referral and are diverted from my view at all. So that's how it works in Clark. And Chief Scott, if you want to add anything to that before I go on to the rest of the PowerPoint.
Good morning again. Chief Deputy District Attorney Shelley Scott for Washoe County. Our court process is very similar as that described by Chief Duffy. And you've already heard from Ms. Flores, the Director of Juvenile Services. They end up diverting away from prosecution probably close to half of the referrals they receive will be diverted and never even come to my office. Most of those will be misdemeanors because they're not required by statute to send them to us, but the remaining part that can be deferred or referred back to probation can come after a DA review and a decision not to pursue formal charges in the delinquency system, but agree that this child is best suited to be diverted from the juvenile system and handled informally with juvenile probation. So approximately half of the referrals that probation receives are handled informally, and approximately a third of what we receive fall into that category that are referred back to probation. Thank you.
Bridget Duffy again for the record. So an overview of the Clark County District Attorney's Office. So as most of you know, I run the Juvenile Division, and it is made up of 2 divisions inside of it, delinquency and child dependency. I have a total of 58 employees, 29 are deputy district attorneys. I have 9 dedicated to the delinquency team and 20 dedicated to the child dependency team. I am supported by 1 law clerk, 1 investigator, 2 process servers, 1 victim advocate for 9 courtrooms, 13 secretaries, 4 part-time hourlies, and 5 various office assistants. Next. So I put some stats because I know everybody is always interested to see our trends in filing cases. And I always preface this for the last, I don't know, 7 years I've been doing legislation. My office still does not have a case management system for the Juvenile Division. So while these stats are gathered with our partnership through juvenile probation, so I always want to make sure these are kind of rough stats, I will say. They're fairly point on, but it's confusing. And so I want to make sure that the top part of my slide talks about how this is not unique children. So 1 child, so when I talk about I filed 3,128 petitions, my office in 2021, that's not 3,128 children. That could be 1 child with 5 times through the system. So it's not, so just how we pull statistics, it's difficult to pull down to each child having a petition. So you can see from 2017 to 2021, we've been decreasing in the amount of petitions filed. 2020, you all can star, that was a unique year. But 2021, we had an increase of referrals. However, we had a decrease of filings. In my office, only filed 46% of the referrals that we obtained. And that is, I believe, an exact shout out to our diversionary programs. So the harbor came into place in 2016 October, and that was 1 harbor, and then we expanded to 2, and now we are at 5 by 2020. And so you can see that using that to divert these petitions that are coming to us has been a success at this point. The other interesting stat I know that you all like to see is the certifications filed, and Clark, of course, files the most in the state. In 2021, we have filed 159 petitions to certify youth to the adult system, and of those 159, 48 children were certified to the adult system. Do the next slide. So these are our charges. These are our top 10 offenses that we filed petitions on. So in 2021 only, there could be more than 1 charge per petition, and I think that's an important point because it is very rare that the only charge on a petition would be violation of probation or parole. Most of the time, a majority of the time, that would come with a substantive offense. So it would be one of the charges that we would file along with whatever offense that child picked up in the community. We talked a lot about batteries and the fact that they are misdemeanors, and then you'll see that's the second highest offense filed that could be coupled with a violation of probation. The battery by a probationer is considered a felony charge. But the batteries themselves, they're victim crimes. And so if we divert a child to the harbor or divert a child to probation and that child denies the offense, and is not going to accept whatever services are being offered, it often then comes back to my office. And since I have a person victim on a charge, then that kind of weighs the decision to end up ultimately filing a petition. That gives the subject minor who's denying that they committed the battery, that gives them the opportunity to go before a judge and deny it and have their trial in court. And then it allows the victim to know what occurred in the case. Battery domestic violences have been on the rise since COVID. I know that the harbor is it's one of their top offenses that they are dealing with. That stress and tension in the homes is increasing. And a lot of times these cases, we're looking at one child with 4, 5, 6 times that they've been through and offered diversionary programs and have not been successful to the point where the family's asking for judicial intervention. These cases we are seeing often have a large mental health component for the perpetrator child on the parent. Lewdness with a child, and I'm going to combine that with our sexual assault. That has also been on the rise since our pandemic shutdowns. So we have that as being one of our top charges, obviously something that we do need court intervention with. And then you'll see our more serious offenses with robberies and firearms. Next. I'm also always proud to talk about our participation in diversionary services. The harbor's been talked about a lot. I'll be happy to answer any questions from my end you have on it later. I also co-chair what is called the School Justice Partnership. That is a collaboration between the Clark County School District, Juvenile Probation, and the District Attorney's Office. It was implemented by MOU in 2018. It was our attempt to stop the school to prison pipeline. As you heard AD Willihan talk about, kids that are excluded from school are fast tracking their way to prison. So this school justice partnership, we worked to determine what school-based acts that were committed should be dealt with as a diversionary or school-based discipline and not sent to the juvenile justice system. So possession of marijuana on school property, if it's not for sale, just normal possession by a child, maybe with a wax pen, first-time batteries, a phrase, obstructing a police officer, those types of offenses. We have asked that the school districts use our diversionary services and use their PBIS, which is performance-based something. It's their school-based level of interventions before sending them to the juvenile justice system. Again, I think that's a large part of why we are seeing a decrease in filings. And in 2021, General Ford, he put forth a call to start restorative justice in our juvenile system and in our criminal system, but I'm only going to talk about juvenile right now because I'm actively a part of it. And we're using the Harbor program to start these restorative circles where we're bringing the harmed individuals, or what we would call victims, but the harmed individuals and the harming individuals, or the subject minors who perpetrated the offense, together with trained mediators to talk about what happened, how it impacted them, and come to a joint resolution as to how that should be handled. We are dealing mostly with misdemeanors in those cases, although my office has referred some felonies, some like larceny from a person where the harmed individual is getting their property back. So maybe a child stole a cell phone at the park, but they received the property back, so there's no restitution. That is a felony, but we're able to bring those two individuals together, the harmed and the harmer, to talk about, how what happened and how it made them feel, and come to a joint resolution with the families as to how the person who conducted the harm should be consequenced. So some impact of AB 230. This was our bill from last session that excluded certain offenses from direct file or kept them in the juvenile justice system. And those would have been offenses that were use of firearm for children who had prior felonies. So since implementation on October 1st of 2021, so now we're into 7 months, we have had 26 children that are 16 or 17 who would have been sent directly to the adult system, remained in the juvenile system. So 26 children in 7 months remained in juvenile, All of them were firearms cases, robbery with use, discharging a firearm, or assaults with deadly weapons. Of those 26 to date, 3 have actually been certified to the adult system because although they don't directly go to the adult system, the district attorney's office still has the ability to file a petition and a motion to certify them. So the court then makes that determination, and 3 of 26 have. 11 have remained in the juvenile justice system in juvenile placements. So children who are now given another opportunity, because most of them have, well, all of them have prior offenses, but most of them had other opportunities on probation, but we've kept 11 of them that would not have had that opportunity before this legislative body passed AB 230 are still given the opportunity to be in the juvenile justice system. And we still have 12 pending at this time. In 2020, just so you know, because I want to talk about the impact of this on our juvenile probation department, in 2019 and 2020, prior to AB 230, only 21 children in the entire year would have been directly certified to the adult system. So this is creating 26 extra children in the juvenile justice system that are remaining in detention a lot longer. So it is has that fiscal impact that was discussed at the in the 2021 session actually came to fruition on the Clark County Juvenile Detention Center, because they are remaining there for on average 60 days. Our next slide talks about direct files and auto certifications. It's called different things throughout the state depending on where you are, but these were the cases that still children are automatically sent to the adult system. These cases include murder and attempt murder for children that are committed by children ages 16 or 17. So far in 2022, we have had 2. In 2021, we had 18, 2020, 10, and 2019, 16. So we are fortunate that so far, almost halfway through the year, we have only had 2 children certified directly to the adult system or direct filed to the adult system for murder or attempt murder. And before I pass it off to Chief Scott up north, I do want to say to date, we have 120 certifications that have been filed by the DA's office in Clark. 42 are pending those certification hearings. 14 have been granted. 2 of those in 2020 are for murder. They're children under the age of 16. Unfortunately, we've had 2 so far this year. Certifications for murder and attempt murder for under the age of 16 have been going down. So we had 11 in 2019, 12 in 2020, 9 in 2021, and so far 2 with almost half of the year done for 2022. And so I'll discuss the other pieces of legislation right before we take questions at the end.
Thank you, Chief Duffy. Again, this is Shelley Scott, Chief Deputy District Attorney for Washoe County, the Juvenile Division. Starting my presentation, we're divided a little bit different in the juvenile system in Washoe County than Clark is, where Chief Duffy oversees both the dependency and the delinquency divisions. I oversee only juvenile delinquency. Our juvenile dependency falls under our civil division and is overseen by a separate chief and a separate ADA to handle the child dependency cases. In the first slide, I've shown you a breakdown of what our 2 juvenile divisions look like. Our juvenile dependency is a fairly large unit for the size of Washoe County. We have 9 attorneys, one of which is a grant-funded position. They have 4 legal secretaries and 1.5 office assistants to process all their paperwork. In addition to the juvenile dependency hearings, they handle parental termination of rights cases. They handle and will specially appear in some guardianship cases, so they have a very heavy caseload that those 9 attorneys handle. On the criminal division side, our juvenile team has 4 attorneys. One is myself as the chief. We have 2 legal secretaries, a half-time office assistant, and unlike what is available in Clark County, we do not have any dedicated support staff in investigations or process serving. So we will pull out of the general pool for access to those services on a case-by-case basis when the need arises. As you've seen with both Director Flores and has been discussed by Chief Duffy, we have seen a decline overall in referrals, especially during the pandemic. In, excuse me, in 20 and 21, our caseloads and referrals dropped dramatically. We lost, or the cases were decreased probably a third of referrals, and I attribute much of that to the children not being in school. A lot of our referrals come from school police because that's where we have eyes on them for 8 hours a day. When there is not that supervision, it defers back to the local law enforcement agencies who routinely do not have as much contact with youth, which is a good thing. So we did see a dramatic decrease in the referrals that came to our department, as Director Flores also noted a decrease in referrals to juvenile services overall. Our caseloads have been fairly steady for the last 5 years, aside from the pandemic. We've gone between 1,500 to 1,700 referrals. As Chief Duffy indicates, we don't have, or we're in the process of actually getting this week a case management system that will be able to allow us to pull much better numbers in a much wider variety of cases. So these are generalities over the last 5 years that we've been able to pull by hand on a rather quick basis for this committee's use. Certifications in Washoe County are very few. We have a vetting process before we even file a petition. It necessitates the youth usually remain in custody a little bit longer, but I think the vetting process results in fewer youth being certified, fewer hearings actually going forward for certification, and a much greater stipulation by the youth to be transferred to the adult system after the vetting process has occurred. We staff internally with the juvenile team. If there's a recommendation from the juvenile team for likely certification, it is staffed with our ADA and a criminal division chief to make sure that they both are approving the transfer. And in this process, we also consider mitigating information. We seek information from the child's defense attorney for any mitigation, any evidence they want us to be able to present internally and to our chief or our assistant ADA as the vetting process goes forward. And I think the certification numbers that you see bear out the fruit of that process. In 2017, we've only filed 4 motions for certification. 4 of those the youth stipulated to transfer, and there was 1 that we did withdraw. In 2018, there was only 1 motion filed. That was for an attempted murder case where a youth was under 16. That motion went forward to hearing and was granted. 2019 was a very big year for Washoe County. It was unusual that we had 11 motions for certification filed. However, of those, 9 of the youth stipulated to transfer. 1 went to a hearing, was granted, and 1 was withdrawn. In 2020, we filed 3 motions. 1 stipulated, 1 was withdrawn, and 1 youth was incompetent. So he was held in the juvenile system and sought treatment for a significant amount of time until he aged out of the system. But unfortunately for our victim, the offender in that case could not be held accountable. And I think that's where some of the housing issues with incompetent, long-term incompetent youth may be important for this committee to consider on an upcoming basis. Right now, we only have one motion pending from 2021, and we have not filed any yet in 2022. So our numbers, as you can see, as compared to Clark County, are significantly smaller. We have a significantly smaller population. Direct files also reflect the difference in the youth in Washoe County. One case in 2021 was a direct file that was a murder, attempted murder. In 2022, we currently have 2 that are pending, and the effects of AB 230 in Washoe County were not nearly as dramatic as they were in Clark County. Based on the prior felonies between 2018 and 2021, we only had 5 cases that went up on a direct file, and that was before the AB 230 came into effect. Since the application of AB 230, only 1 case has remained in the juvenile justice system. The state decided not to move forward with adult certification, and the youth remained in the system, was sent to correctional care. We've touched briefly, or I believe DCFS touched briefly on SB 7, which was the protection order hearings. The district attorney's office is not a party to the protection order hearings. I sought information from our court master who oversees the protection order hearings for juvenile justice to get some numbers from her on what she's seen since SB 7 was enacted. She indicates that they have set 36 hearings where the minor is, the adverse party is the minor. Not all of those are 36 different youth. Some of those she indicated were hearings that had to be continued so the youth could converse with counsel, so the proper service could be had. However, in all cases that came before her, appointed counsel was given for the adverse party. That is typically by the Washoe County Public Defender's Office. I know my partner, Ms. Bershey, has prepared some slides with respect to their participation in these protection order hearings. It was also one thing that the court master noted, that in many of these cases, if not all of them, the petitioner is also a minor child, and in none of those cases was the petitioner minor child afforded counsel. Chief Duffy and I both collaborated on this moving forward slide. I will let her make some final remarks to the committee about our thoughts in moving forward. And I want to thank the committee members for their time this morning. I'm available for any questions.
Thank you, Chair Scheibel. Bridget Duffy again for the record. So our bright sun looking at moving forward on this slide. Some of the things that the 2 district attorneys' offices have talked about: we are still in need of competency and restoration services across the state. I failed to put this, the SB number. I believe it was 366. It was Senator Orenshaw's bill. Became where the DA's office, were trying to push to mandate that beds be available within our state mental health facilities for juveniles that are deemed to be incompetent. So we were trying to move forward with. Can you put my slide up so I don't know if it's up there for them. So that thank you, Mike. So that we have a place for juveniles that are deemed to be incompetent to either be restored or to get other types of treatment. That bill turned into a study bill, Oversight Commission. So we're working forward with that. We really do need, and you've heard this all morning, improved mental health services in our schools and our community. The DA's offices join in that voice. We see a lot of the children that we are taking on petition to court have deep trauma and mental health issues. It doesn't make me feel good about it, but this is how we have to get their help, because families themselves are unable to access services in the community, and their escalation of their violent behavior is getting to a point where the family needs the assistance of somebody other than themselves. So our juvenile detention facilities are much like our adult detention facilities, and they are becoming mental health hospitals. So we clearly need better, more robust mental health services. The Medicaid funding is a huge issue. I know this is not this committee, but it is a big issue in getting providers. We joined the charge for needing a blended sentencing model that includes developmentally appropriate programming for our violent youthful offenders. When I have a 14-year-old who commits 2 murders and 1 attempt murder only because the victim did not die, the placement options for that juvenile in the juvenile justice system are 0. But that is our most violent type of offender with a very underdeveloped brain and a lot of trauma, right? So we really need to get moving on these bills that have been put forth, and I believe my friend Holly from the ACLU is going to continue to talk about those. And we agree there has to be something that comes between a juvenile who commits an offense that is violent and adult and lovelock until they are of age to be able to transition. And so we support that blended sentencing model. And as Chief Scott said, we have a desire to address the juvenile victims of domestic violence not having counsel at those protection order hearings. In most of those cases, because they're dating relationships, we are filing those petitions of domestic violence. And so we have the perpetrator or the harming individual getting attorneys at the civil protection order hearings, and then having our victim not have that same protection. I want to follow up with a couple of the other bills from last session. The easy one, SB 108, you heard AD Wheelahan talk about the training that we had in Clark County. It is phenomenal what it did for my office and my attorneys that I mandated take it. I shared, and I would love to share with you all, I shared with Senator Scheibel through the interim and Senator Wiener, who runs the Children's Youth Legislature, that I saw an article where there is another state that is picking up a similar bill that this body passed last session to include that adverse childhood experiences as part of training. So I believe that what Nevada did was at the forefront of recognizing that people who deal with children in the juvenile justice system have to understand what an adverse childhood experience is and how children respond to stimuli based upon those experiences. So way to go, Nevada Legislature, because other states are looking at your bills now. As to AB 158, so in Clark, the implementation, it's a little odd because the statute requires on the first or second referral, on the third referral, it comes to the DA's office. Well, in Clark, first time and second time misdemeanor marijuana offenses are not referrals to the juvenile justice system anymore. They are diverted to the harbor, so we don't even have a counting system to know what the first and second are to even get to the third. So we had to come together with Juvenile Justice Services and the managers of the harbor to say, you guys can take number 1 and number 2 and number 3. And when it gets to number 4, we're going to refer it to probation intake, and that's going to start the clock all over again. So we're really doing, we didn't want to have to start giving children juvenile records when we don't do it now, because we divert them out of the system altogether. So we had to find a fancy way to do it, but it is in the best interest of the children at this time. So it's not a way to, it's diverting and not circumventing the law. It's just no way to capture that in our system. All right. And Chief Scott, if you have anything to add to AB 158.
Chair Scheibel, Shelley Scott, Chief Deputy, Washoe County. I would echo Chief Duffy's concerns or comments with regard to the original referrals for marijuana and alcohol possession. Our juvenile probation department, juvenile services, we do not have a harbor up here, but juvenile services has their community programming, and it is rare that even before the inaction of AB 158 that we saw a referral for a misdemeanor marijuana or alcohol case until the third or fourth offense, unless the child was given services and refused to accept them, or the child very quickly escalated even though services were provided. So I think primarily both Washoe County and Clark were acting already and in diverting the very minor offenses out of the juvenile delinquency system even before the enactment of this bill. Thank you.
Ms. Bridget Duffy, for the record, that concludes our presentation, and we'd be happy to take any questions that you may have.
All right, thank you. I think we will have a couple of questions. I also wanted to note for the committee and for others, I think that we touched briefly on AB 158, which was Assemblywoman Monroe Moreno's bill from last session. It was a fantastic bill, and she's also submitted a public comment, which is available online to review about a kind of gap in the measure that we intend to fix next session. So I know that she couldn't join us today, but it's all in writing on our committee website. So we appreciate her for that, and I encourage all of you guys to read that and just get up to speed on what's happening with our treatment of juveniles' marijuana offenses. And with that, I will go ahead. I'm going to go to questions. I'm also going to let you guys know that my plan is to break for lunch after this presentation. So if that affects your planning now you know. So I will go first to, I think Assemblymember Nguyen, you had a question? Go ahead.
Thank you, and thank you for your presentation up north and also down here, down south. I have a couple of questions. One, did you have a chance to read Assemblywoman Monroe Moreno's comment regarding like the disproportionate treatment of like vape pens, like marijuana vape pens with children? No.
Bridget Duffy, for the record, I have not.
And up north, did you have a chance to read that comment as well?
Shelley Scott, for the record, no, I have not had an opportunity to read that comment.
Well, I guess under any circumstances, I would encourage you to do that and reach out to Assemblywoman Monroe Moreno, because it sounds like she is, looking at some legislative fix going into 2023. But as far as like you had mentioned, you don't always charge everything and things come to you differently. One of the things that she brought up in her concerns is the ability and the discretion that you have in your offices on whether or not to charge certain things surrounding like marijuana. And I know that there is a lot of things regarding that. Can you kind of discuss like how you take into consideration like moving trends away towards criminalizing that type of behavior?
So Bridget Duffy, for the record, I don't consider, this is my personal opinion and not my office's opinion, I don't consider marijuana much different than alcohol in that we do not support children being under the influence of alcohol. One, we're talking about brain development, right? How often am I told that I need to treat children differently because their brains aren't fully developed? And I have to recognize that they make boneheaded decisions because their brains aren't fully developed. And there is a difference between boneheaded decisions and true, armed robbery type behaviors. I am extremely concerned about the impact of marijuana on those underdeveloped brains, as well as I am about alcohol on those underdeveloped brains. I also have concerns when I see the children that we do get for the 4th and 5th petitions and 6th petitions, that they are then escalating, right? The gateway drug. So there is, in my mind, we divert most of those kids, and I haven't seen whatever it is that may be the issue, and I definitely am going to look for it and see how we can address it in a satisfactory way. But there are the kids that are kicking back at a house party, and then we have children that are using it every day and showing up high to school every day. We have children that are using it and driving, running red lights at a high rate of speed and taking the lives of individual citizens in our community. So I do have some concerns about marijuana usage, and I don't think I would treat it any differently than I would alcohol.
I guess that's the concern in Assemblywoman Monroe Moreno's comments, is that it is being treated differently than alcohol. So I know it's not your office's policy per se, but obviously there are concerns. I think we all have those same concerns about children and any kind of substance abuse, and that how it implies. But I think that's some concern, is that the marijuana possession is treated as a felony, and now the alcohol violation is not. Is that correct?
Bridget Duffy, for the record. Possession of marijuana with intent to sell is treated as a felony, but not just personal possession. In fact, that's the number 1 or 2 charge that's diverted to the harbor, is possession of marijuana, possession of drug paraphernalia. Those are and you can see it's not even one of my I don't believe it's one of my top 10 offenses for 2021 of being filed, because we divert them to the harbors.
And maybe this is a question maybe for Shelley up north, as it specifically pertains to vape pens. I don't know if she can address that.
Thank you, Assemblywoman Nguyen. I can address that. My office has differentiated between concentrated THC and marijuana, just as the statute has differentiated between the green leafy substance known as marijuana and THC, or concentrated cannabis. We have looked at all of the clinical information with respect to child brain development, the use of the concentrated THC, and we have filed those charges. We have filed those charges only after an assessment by probation and a substance abuse evaluation that recommends treatment. Especially in cases where there is reported daily use or several times a week, or it's been a long-term pattern of use for a youth. It is my understanding that the school district is not sending all of the vape cases to our offices or making law enforcement referrals for all of the cases. Much is being handled in the school districts informally with suspension and education. Once the referral does come to my office, if probation's assessment and the substance abuse evaluation indicate that this is minimal use, meaning very experimental, there are not other mental health needs that need to be addressed, no other substance abuse needs that need to be addressed, then we are authorizing those to be handled informally with probation without the filing of a petition. If intervention is indicated by the substance abuse evaluation, however, we are filing the petition, and after filing the petition, on almost all cases, are referring the matter back pursuant to what's called a supervision and consent decree, which adds a layer of support to the youth with a probation officer, but upon completion of the programming and the terms that are imposed by the court, the charge is dismissed at that point. So it's an intermediate handling that we are utilizing in cases where primarily we see it in vape pens, but where the vape has become more of a crutch for the individual, or we're seeing an elevated use. And it's not your experimental, I was at a party and we were passing around a vape pen. Those are not the kind of cases that we're taking into the system, but we do differentiate between possession of the green leafy plant material and concentrated cannabis because it's differentiated in statute. Thank you.
Thank you. And then just one other question. I know that it doesn't really affect this committee per se, but you had talked about having a problem. Is it a problem finding Medicaid providers? Like, what has been your experience, with that either down here or up there?
Bridget Duffy for the record. The issue is the Medicaid rate. We are having an issue finding providers because Nevada's Medicaid rate is so low compared to other states that providers aren't willing to come to our state to provide services for us. And also, we find it difficult to send children out of state who need treatment because providers will not accept our children because we pay at such a low rate. I know, and I will say, because I never want to talk about my state partners, but it is a conversation we've been having with them over the interim that something needs to change and we need to readdress our Medicaid rates.
Are there any services that are just not covered by Medicaid that are also problematic? I know in a previous meeting we heard about how inpatient programs were not covered. Do you have some of those same struggles with your juvenile?
Bridget Duffy for the record. We definitely have a struggle. I've had a struggle here in Clark with kids, dual custody kids, so foster kids that are also on the juvenile delinquency side with in-state drug treatment programs, inpatient drug treatment programs, to the point where Clark County was making a contract to pay just straight county funds to get a child assistance because the only in-state provider that would take a child inpatient for drug treatment did not take Medicaid.
Thank you. That's all I have.
All right. I think Senator Harris was next. Go ahead.
Thank you, Chair Scheibel. This question will be for both here, Ms. Duffy, and as well up north, Ms. Scott, if you could address it as well. We heard a little bit about national disparities in sentencing and in certifying. Are either offices tracking whether there's currently a disparity here in Nevada in our own practices? And if so, even if not so, are there any efforts to be kind of proactive in doing our best to ensure that those disparities are not creeping in?
Senator Harris, Shelley Scott, Washoe County DA. Our prior case management system did not have the ability to track the information that would be utilized to establish any kind of a racial bias or disparate treatment among our youth. The new system that has gone online this week does have the ability to do just that. So Washoe County is moving forward with an ability to identify our youth not only by gender but by other ethnic categories and be able to pull the data to see if we have any disparate treatment. I know when I'm charging a case, as well as my deputies, that we don't look at the race of an individual. That information is buried in the police report on biographical information. What I'm looking at is the nature of the offense. I think where we may see some disparate treatment, however, is in the ability for our families to access resources outside of the criminal or juvenile delinquency systems. If the families have access to therapeutic services and or private placements, that will mitigate the ability or the need to use correctional placements or detention facilities or the judicial and juvenile delinquency system to access those services. It is definitely something to look at moving forward. I am not aware of any current information that I can pull from our system to answer that question.
Bridget Duffy for the record. Thank you for the question, Senator Harris. And I am going to say with absolute clarity, it is disproportional in Clark County. There's no denying it. I believe part of the presentation from Juvenile Justice Services highlighted it. Having said that, my office actively participates in the diversionary programs, which are assisting in cutting down the numbers. The school justice partnership that I talked about, school districts, well, maybe you don't, but school districts expel and suspend children at a very disproportionate rate. That partnership is addressing things such as the code of conduct, addressing restorative practices, and addressing not sending low-level offenders to the juvenile justice system, because we know that there's an issue there as well. So we're really working there at those grassroots misdemeanor, some felony gross misdemeanors that are nonviolent offenses to try to get those out of the system and allow those families to access services without coming in. As I start getting into cases that involve firearms and robberies and cases that involve murder, attempt murders, it is not as easy to divert those cases, right? So they come in as we get them, as Chief Scott said, they come in from law enforcement. The demographic information is buried somewhere in a police report. We don't really go looking for it, but there's no other, I don't have a mechanism of capturing it. I rely on juvenile justice's case management system to tell me what the numbers are.
Just a quick follow-up, Chair, if that's okay. I appreciate your frankness and honesty, and I probably just as sure that there's disparities in the north as well. I think that's just a feature of our system and not on any individual specifically. And I would really just encourage you both to try and be as proactive as possible, because complacency is what leads to these disparities, not necessarily intentional acts on the behalf of one individual DA on one individual case. And absent a intent to chase down these gaps, they just continue to grow. So thank you.
All right, Senator Pickard. Oh, I'm sorry. It looks like one of our presenters wanted to also weigh in on Senator Harris's most recent comments. Go ahead. But remember to state your name.
Michael Wheelahan for the record. Thank you for that question, by the way. So we are aware and we are recognizing the issues, the racial disparities. So we've actually created a diversity committee where we use data, and we're creating processes within our own systems because we know they exist. And we actually have started a CQI division to look at the impacts of decision making based on a racial lens. So we are being very proactive, and we're going to do our best.
Now we'll go to Senator Pickard. Thank you.
Thank you, Chair Scheibel. First, I will say, having been a member of the school district juvenile justice partnership program from its inception, I want to applaud Chief Duffy and A.D. Wheelahan for your participation and the great progress you've made. That would not have happened had it not been for your participation, and I'll make a shout out to Jack as well, because that has made great strides in addressing the issue. Obviously hasn't fixed it. I don't know that we'll fix that in our lifetime, but we'll certainly try. My question, though, goes to back to the cannabis issue, the concentrated cannabis. And this is something I have personally been connected to through my work with youth recovery programs. My wife and I participated. We facilitated a 12-step group for youth for many years, and in the process did a fair amount of research into things like marijuana as a gateway drug. And just from an anecdotal standpoint, we spent time with literally hundreds of kids, and without exception, all of the kids that were suffering with drug addiction or any kind of substance abuse addiction started with marijuana. In any event, my understanding is there's a pharmacological difference between the, as Chief Scott said, the green leafy substance and the concentrated THC that we see in these wax pens. And there's an associated difference in how it affects brains. Assemblywoman Moreno suggests that there's a 1/8 ounce cutoff for those. Is there any evidence in the record that we have so far to suggest that any amount is tolerable, or we have a threshold after which the damage is done? Is there any kind of evidence to support that, or is that well, maybe that's a question for her, but is there any evidence to support deviation from what we're currently doing?
Bridget Duffy for the record. Chief Scott, I'm going to pass that question to you because we, while we believe we could file, we are diverting those cases at this point for sort of what Washoe is doing. So I'm not sure if there is an answer to your question, at least not from my perspective. I'll see if Chief Scott has one, but we are diverting them so that they can get the full assessments and determine what is needed to treat that child. And then if they continue to come back to the system, that is when we would ultimately file. Chief?
Thank you, Chief Duffy and Senator Picker. I don't know that it is a one and done situation. In speaking with our clinicians at Quest Counseling, who is our residential program as well as who treats most of our youth, they have articulated to my department that they have seen differences in the way the youth respond to concentrated cannabis, the way the brain responds to the concentrated cannabis as opposed to the green leafy substance. The percentage of THC in most of the vape pens that I've seen coming out of the high schools, middle schools, and even some elementary schools is 85% THC, 65 to 85% THC, which is about 4 to 5 times the concentration of THC that you find in a very well-grown green leafy substance. So I can't say, Senator Picker, that it is a one and done, damage is done. It is definitely a situation where damage occurs much more quickly. And we want to, no pun intended, but nip it in the bud. These children, we are seeing vape pens being sold on school grounds. They're being used on school grounds. The gummies are being brought in, and kids are ODing because friends or family members have given or bought the cookies, the gummies, the pens, and our youth are suffering the consequences. So those are the reasons why we differentiate between the THC concentrates and the plant material.
All right, thank you for that. And you just addressed one of my follow-ups, so I won't ask that one. But Ms. Duffy, I am interested because I'm aware that we try to divert 100% if we can. But what I wasn't aware of was that CCSD is not referring those to the juvenile program. Is that by design? Is that by policy? Or is that just an issue of happenstance? Maybe they don't have the manpower. What's driving that? Because I wasn't aware of that.
Bridget Duffy for the record. Thank you for the question, but I have a clarification. When you say not referring them to the juvenile program, you mean citations for the THC?
Correct.
So Bridget Duffy for the record. Yes, so they are referring, but they're referring them and they're going to diversionary services, or for a first-time offense under the school justice partnership, they could do school-based services. It's up to their discretion as a law enforcement officer. So they're still being seen. The harbor, it's one of their top 2 charges. It used to be one of our top filed charges, but we're using the program because it becomes, in Clark, what we do is say, does this child need a probation officer or does this child need an assessment and services? And for something like that, that's something we see that kind of borders on a first offense, maybe on a second offense, as somebody who needs an assessment and services, and those are best done by the programs that we build up outside of the court system, but eventually could become part of the court system as they do not accept those services or the services do not change the behaviors.
Right, thank you for that, because I was a little alarmed. I had interpreted what you said as they're just keeping it in-house, they're not saying anything, and that's not my understanding of how that should happen, so I appreciate the clarification. Thank you, Chair Scheibel.
All right, other questions from members here? I'm not seeing any, so we will go to Carson City. Any questions from our members? All right, I see somebody raising your hand. I think it's Assemblymember O'Neill.
Thank
All
you,
right.
Chair. You're right.
Go ahead.
I'm not sure this question can actually be answered. We've talked a lot about Washoe County. We've talked about Clark County. I'm just curious, do we have any numbers? How are the juveniles being treated in the rurals? Do they have the diversion programs, their arrests? We've got 15 other counties to deal with, and I know the numbers aren't there, but I'd really be curious to see where they stand on some of these issues too. I know we got Washoe, Clark, DCFS, if they could chime in. Can anybody give me any assistance or information on the rurals, at least, the 15 other counties?
Hello, this is
Bridget
Liz
Duffy
Flores.
for the record.
Oh,
Thanks. Liz, excuse me 1 second. This is Bridget Duffy for the record. So it may help you to know that myself and Washoe County DA's office, as well as the DA out in Carson City, we routinely spend time together on teams, kind of discussing issues. And I know I can't speak for the other 15 counties, obviously, but I can say that they are, at least in Carson City, facing similar issues that we have, having the same type of diversionary programs, not as robust, say, as the harbor, but they are diverting more children and seeing the same amount of top offenses within their county. So we spend time talking to each other on how we operate and how we process cases and what we're seeing within our counties. Liz might have a better answer.
not better, just different. This is Liz Flores for the record. I wanted to add to that also in our state, as A.D. Wheelahan mentioned previously, we have the Nevada Association of Juvenile Justice Administrators, where all of the chiefs, assistant chiefs, and detention managers and other staff across the state who work in juvenile justice, including state membership, discuss juvenile justice matters. And just from that interaction, it's very clear to me and others that the rurals also participate in active diversionary practices. There are unique constraints and resource issues that are, unique to rural agencies. Also, we are required to report to the state annually what our diversionary numbers are. So the state does have access to that data on an annual basis. Thank you.
Thank you. I appreciate that. And you said the unique. I guess that's what I'm looking for, is some of those unique differences and how they're handled out in the world. And are we meeting the juveniles' needs to ensure that we don't have them as adults? That's really what I'm trying to drill down to.
Liz Flores, for the record. I believe on the Juvenile Justice Oversight Commission, there is a member, Commissioner Pauline Sala, who routinely speaks on behalf of the rural jurisdictions. She is over in Humboldt County. I think if at any time this committee asked for, wishes to have specific information about how the rurals are managing their diversionary practices, I'm certain that she, on behalf of the rurals or through NAJA, can provide that information to this committee.
I appreciate that. Chair, thank you for the time. Possibly, maybe at next meeting or in the future, we could have a comment made or presentation on the rules by Ms. Sala. Is that correct?
Liz Flores, for the record, yes, Director Pauline Sala from Humboldt County.
Thank you very much, and thank you, Chair.
And thank you, Assemblymember O'Neill. It sounds like Ms. Sala was invited to this meeting and maybe wasn't able to make a presentation or able to send anybody from NAJJA. However, if I'm wrong and someone is here and wants to make a comment, now would be a great time. Otherwise, I would encourage them to follow up with Assemblymember O'Neill. And of course, we would welcome them at a future meeting. So I'm not seeing anybody hopping up or calling in. So I'm thinking they might be listening in from the internet. So are there other questions from our members in Carson City or anywhere else? All right, I am not seeing any. So that concludes agenda item number 7. Thank you. Thank you for your presentations and all of your hard work. This brings us to our lunch break. We are going to take about a 40-minute break. I'm going to ask everybody to be back here at 12:30. That is 12:30 noon, and we will be starting back up with the public defender's offices. Then we'll talk to the ACLU and have some public comment. All right. The committee is in recess. All right. We are going to call this committee back to order. People are filing back in, and I think some of our members did have to leave early, but I hope they will catch up with the recording later. I should have checked to make sure that our presenters were ready before I dove in. We are on, yes, I see somebody with a very friendly face nodding at me. We are on agenda item number 8, our overviews from the public defender's offices. And I thought I saw someone online from Washoe County, but as we have been doing, there we are. With the rest of the presentations, I will leave it up to you guys to tell us how you're going to divide and conquer. So without any further ado, please go ahead, introduce yourself, and tell us about what's going on with public defenders.
Good afternoon, Chair Scheibel, members of the committee. I am going to share my screen and we will get started with our presentation. Maybe. Perfect. So as you all know, my name is Kendra Birchie and I'm with the Washoe County Public Defender's Office. I have the pleasure of presenting on behalf of our office, along with Jennifer Frazier, who's the Chief Deputy Public Defender of the Juvenile Division down in Clark County, about the legislative updates, recommended legislation, and trends that we have seen. So just to give an overview of our presentation, here's just what we're going to go through: the updates, then the legislation, and then discuss those trends. So I'll turn it over now to Jennifer Frazier to discuss an overview of the office for the Clark County Public Defender's Office.
Good afternoon, Chair Scheibel and members of the committee. Thank you for inviting me today to discuss the topics of juvenile justice specifics for our office. My name is Jennifer Frazier. I've been a public defender for a little over 15 years. I've been in the position of Chief Deputy Public Defender, the supervisor at our office for the past 3 years. A little bit about our office, or just juvenile court. In general, all children who come before the court when a petition is filed are appointed counsel, whether it's a misdemeanor, gross misdemeanor, or felony offense. Our children in juvenile justice court are also, counsel stay on, unlike other jurisdictions, post-disposition. So if there's issues after dispositional hearing, and a dispositional hearing is akin to a sentencing hearing in the adult system, counsel remain on the case for issues while a child's on probation, if there's restitution issues, placement issues, a whole host of issues come up after a disposition, and our office remains on the case for those. Our office has 12 attorneys, including myself. We have 4 attorneys that are specifically devoted to the certification and juvenile sex offense cases. Those are kind of a specialization within our specialization of juvenile defense. All of our attorneys handle the multiple specialty court calendars that we have in juvenile court, and I'll list those for clarification. We have certification calendar. We have mental health calendars, which primarily deal with placement issues. That's been a topic brought up throughout the morning about difficulties with competency, severe mental health cases, and those cases end up on that calendar. Juvenile sex offense calendar, a sexually exploited youth calendar, dual status calendar. Dual status describes children who are both in the systems of juvenile delinquency and dependency. So an open DFS case as well as delinquency. So those youth would have both a probation officer and a DFS caseworker. And the goal is to have all parties work together. That's a newer calendar the past few years. Drug court calendar, a restitution court calendar, as well as a day court calendar, which deals specifically with youth who are on the autism spectrum disorder. We have a total of 22 employees, including investigators, social workers, secretaries, and clerks. Just to go over some data with regard to our more serious cases that we handle, in 2021 calendar year, we had approximately 70 certifications that we handled. Those are cases that weren't necessarily ended up certified, but where the state sought certification, and approximately 112 juvenile sex offense cases. In 2020, as discussed earlier, that was an anomaly with lower cases, although we did have 65 certifications, so the number wasn't that different from where we were last year, and then 136 juvenile sex offenses, and then 2019, 70 certifications, 158. So these are just cases that our office handles, but you can see the certification numbers always hover around 65 to 70, and there is, although there is some variation within the sex offenses. And I will turn it over to Ms. Birchie to discuss Washoe County office.
Thank you, Kendra Birchie, for the record. The main difference, and I think Ms. Fraser did a great job, and you've heard from the other presenters of really what we do with the Public Defender's Office when we represent our clients involved in the juvenile justice system. The biggest difference between our office and Clark County's office is obviously the number of attorneys. We only have 3 attorneys who are designated specifically to juvenile justice. So they are the attorneys who handle any case that comes in with a minor child who is under the purview of the court system. And that does also now include those TPO hearings as well. So there's only 3 attorneys that we have designated just for those positions. Because there's only 3, we do have some coverage where our office, we do cross-train. And so our members of our attorneys are able to assist as needed. That is not our preference. Obviously, we want to have those designated to who handle the juvenile justice issues, covering those cases. Like, as you saw in the other presentation from the Washoe County District Attorney's Office, we do not have a full-time secretary assigned. We do have one who assists. We do not have a full-time investigator who just handles these cases. They have to, they also provide coverage for other attorneys as well. So with that, I will turn to our next issue. Of going to the legislation that was just passed. So I'll start with SB 7, and as a reminder, that is the Temporary Protective Order Bill, which does authorize those who are the adverse party to have counsel. Our office has been providing counsel to those individuals, to those children. Since January of 2022, we've had 18 cases. We conflicted off of 3 of those cases, which means that they went to either the alternate public defender's office or conflict counsel in order to assist those individuals. In hearing these cases, we're still working through some of the process issues. There's been some issues in terms of making sure that we get notified in time before the hearing to actually meet with our client, to go over the facts and figure out what defenses, if any, are how to proceed with that case. There's also some clarifications that we'd like to see. And so we're working with stakeholders to find out, is this the best system in terms of the standard? Right now, it's this, whether or not it meets the satisfaction of the court. So there's some issues of whether or not possibly the delay in when a case is filed versus when the incident occurred, whether or not that needs to be added into statute to have some form of immediacy involved in these hearings. We still have the concerns about invited conduct since the applicant is technically the parent, at least how it's been appearing in our system is it's the parent who then is the applicant. And then that's not the person who is in court or in the classroom potentially with the other child. And there's still that issue of whether when that adverse party has the applicant is the one who reaches out to the adverse party, obviously still there, if there's a TPO in effect, the adverse party can't respond, but we still just have, especially with children, some issues of how this is going to play out. We have not seen that a case that was dissolved has been sealed. So we're working forward with the courts, as well as we'll be reaching out with a central repository just to make sure that that is being done, since that is a crucial issue to make sure that if this case was dissolved or didn't go forward, that information is sealed so that it doesn't impact this child negatively. And when I mean that we don't know that it's been sealed, we haven't received a return from the central repository indicating as such. And Jennifer, I don't know if you want to pipe in now about how your office is handling AB 7 or SB 7.
Jennifer Fraser, for the record. Thank you, Kendra. I reached out, our office is not handling these, but I did reach out to the hearing master who by administrative order, the hearing masters in our juvenile court have been responsible for handling these hearings. Since January 22nd, there have been 49, 16 in April alone.
Kendra Birchie for the record. Now I'll turn to AB 158. This is the bill that we were just discussing a lot with the Clark County and Washoe County District Attorney's Office. What we've noticed, as indicated by the Washoe County District Attorney's Office, is that they are interpreting marijuana as not including all forms of marijuana. As part of our testimony on the bill, we believe that the intent was to include all forms of marijuana. And the whole purpose is just to make sure that we have equal justice and we have a system in place so that all children who appear before the juvenile courts, whether or not it's in Clark County, Washoe County, or in any of the rural jurisdictions, know what the penalties are and what they're facing, and that they're evenly distributed. Unfortunately, we do not have the same diversionary programs like the Harbor up in Washoe County. And so this is a very important issue because children who have a vape pen on campus are facing that felony charge, which of course has a whole slew of issues, which we believe that we had resolved with AB 158. So we will continue to work. We've already been working with the District Attorney's Office, and we will continue to try to work with them, as well as Assemblywoman Danielle Monroe-Moreno, to make sure that we capture these individuals correctly. And just to pre-shadow some questions I think I might be asked, what we're hoping to do is just have it treated the same as marijuana, so that the children would be receiving some form of informal probation. So it's not that someone who's caught on campus with a vape pen doesn't face any penalties or any treatment options. We just want to make sure that it's treated the same way as we had anticipated with AB 158. And Ms. Fraser, I'll turn it to you.
Jennifer Fraser for the record. Thank you, Kendra. I echo everything that Kendra just testified to regarding the disparity in treating marijuana versus the marijuana concentrate. We heard testimony earlier from DA Duffy indicating that this isn't a present issue in our jurisdiction where we're not seeing these charges, although her testimony was that she does believe with the current law that she does have the authority to do that. So I would welcome the fix and to look back at the legislative intent of AB 158 when that was enacted in 2021. I'd like to move on to our discussion about AB 132. AB 132 was 2021 legislation which simplified the Miranda warning for youth. I don't have any specific feedback about this change other than that it's very appreciated to see developmentally appropriate language for our kids. This is a good time or a good segue into talking about potential legislation to move forward from that change into talking about ideas about enacting legislation to prevent which prohibits peace officers, law enforcement officers from making false statements during an interrogation to invoke a child to confess. There has been recent legislation in both Oregon and Illinois that passed that law in 2021. I don't think most people even know, because I know when I'm talking to my clients and their families, that they don't understand that it's perfectly legal, perfectly acceptable during an interrogation for an officer to tell a suspect, whether a child or an adult, that there's evidence, that they have evidence that in fact doesn't exist, that they have video surveillance of a child committing a crime that doesn't exist, that they found the child's fingerprints in the room of a burglary that doesn't exist. The problems with that is that it leads to false confessions, and we know that false confessions are more of a problem for youth than it is for adults. That's why this proposed ideas for legislation is specific for kids to try to curb any type of false confessions. And that would be, and that's the goal, is to reduce the likelihood of false confessions by prohibiting any kind of false statements being made during an interrogation. And I'll pass it along to Ms. Bershey to discuss that as well.
We would just echo the same, Kendra Birchie, for the record, of how important it is to ensure that our children are protected. I know that both Assemblywoman Krasner and Assemblyman Flores worked very hard in the last legislative session to ensure that our children are afforded all the protections that they can, because of the unique circumstances that deal with having children with their brain development. So we appreciate the hard work that's been done already in this area. And we believe that this is the next natural progression to ensure that our children have what they need when they are deciding whether or not to speak with law enforcement and what information to provide them with. And with that, I'll turn back to Ms. Fraser to talk about AB 230.
Jennifer Fraser for the record. In discussions for AB 230, this was the legislation that's been discussed today that limited the number of direct files or auto certifications depending on where in the state you are. As expected, we heard stats from Ms. Duffy earlier this morning about the certification numbers increasing. That was expected when we were in discussions about this legislation. I noted looking at just kind of a 6-month snapshot from November 2021, the law was enacted in October of 2021, kind of seeing the difference in the immediate 6 months after, where we're at about 50, where we're handling about 50 certifications, and then comparing that to prior, that same 6-month snapshot, 32 and then 35. So the numbers have increased to where I think we expected approximately 2 to 3 extra cases per month. So that's in line with what we had talked about. And I wanted to discuss when we're eliminating direct files, then the natural progression is we're increasing certifications. So the intent to eliminate direct files is the automatic transfer of a child into the adult system. But our goal as an office and as well as Washoe County is to decrease overall transfers to the adult system, whether it's through an automatic process or the discretionary certification process. There was discussion earlier about the racial disparity in juvenile justice. I think when you're looking at diversion cases, which are the lower level offenses, you'll see disparity. But as you go through the system and you go to each higher level of care, probation, then correctional placement, and then certification, I think you'll see the disparity widen as you get more and more serious or more higher level of cases. This is a snapshot of the cases from our office. So this isn't of the entire certification cases from the Clark County District Attorney, but within our office, the cases we handled, the 70 that we were appointed to in 2021, the numbers are clear. We're 21 Hispanic, 36 Black, 10 white, 2 Asian American Pacific Islander, and 1 Native American. So there you have 81% of certifications are Black and brown children, 85% non-white. And then, so that's a clear snapshot of racial disparity in the certification process. When we're looking at the petitions, and a lot of people, I think, would think that the certifications are used for the worst of the worst, the more serious offenders. But looking at the numbers, many of the cases that the state is seeking to certify to the adult system are on their first petition to juvenile court. So that means those kids didn't have any prior services from the court. They may have been through the harbor, but they had never been before the judge. So those are first petitions, their first arrest, their first time in detention, and then those kids and their families are being, facing the certification, facing the adult system. Many of those kids can also be as young as 14 or 15 years old. The way the statute is written today is that any child 14 or older who's accused of committing a felony, what would be a felony offense as an adult, is subject to discretionary certification. So there's no limitation on what kind of felony offense could subject a child to certification. Of course, the majority of the ones that we see are robbery offenses or other offenses with the use of a firearm, but it's not unheard of to see nonviolent offenses facing certification, something like a possession of stolen vehicle. Our goal is to reduce the number of children transferring to the adult system, and we have suggestions for that. We would like to see an increase in the minimum age for certifications. This would potentially, and to reduce the numbers of first-time offenders facing the possibility of entering the adult system. Would like to see the minimum age increase from 14 and 15. I think we had approximately 10 cases in 2021 of 14 and 15-year-olds facing certification. And to also limit the type of offenses the state can seek certification on, to get rid of that broad discretion that they have and limiting it to only violent offenses and our most serious offenses that we see. And I'll pass it to Kendra to discuss this topic as well.
Thank you, Kendra Berkey, for the record. As you saw from the Washoe County District Attorney's Office presentation, we do not have the same large amount of numbers of children who are either being direct filed or having the certifications from. We do have some concerns about those who are children who are in then at our Washoe County Detention Center when they do face direct certification. I know that our office has worked a lot with the District Attorney's Office and the Juvenile Probation Services to figure out ways with how to better assist those children. I know that that's a topic on a different bill, but I personally have worked with a Deputy District Attorney or Chief Deputy District Attorney Scott on some of these issues, and I've appreciated her willingness to work, and as well as Ms. Flores, on figuring out the best ways to suit our clients and what best fits their needs, as well as the needs of the facility. With that, I'd like to turn to Assembly Bill 251. This is the bill that Assemblywoman Krasner set forth with acting with Juvenile Justice about expungement and sealing. The same thing really with this, that we've had some issues that we've been able to work with the court on just making sure that this is being applied retroactively. We're still working with the programs. As you've heard from the other presenters, there is a struggle to make sure that this is being implemented and that it's being implemented as quickly as possible so that our children who are I guess they're no longer our children, but when they were the children in the justice system, when they turn 18, that they are able to now receive the benefit of AB 251 to get that second chance to seal their records. So it looks like we are still working on implementing it, and much more needs to be done with the court system to make sure that this is done in Washoe County. And we look forward to continuing to work with the partners to make sure that our children are getting that second chance. And Ms. Fraser, I'll turn it to you.
Thank you, Jennifer Fraser, for the record. I'm happy to report, as you heard earlier from Assistant Director Wheelahan, that our jurisdiction takes this very seriously, is in making efforts that this is happening. Of course, there's a backlog, but they're always open to working with me, our office, as stakeholders, have contact people that we can contact to make sure this is rolled out. And it's just really, I'm grateful for this bill. It's nice to be able to talk to our clients and tell them that their record's going to seal when they're 18 instead of 21. When you're talking to a 14 or 15-year-old, 21 just seems so far off. So being able to communicate that and let them know about the 18 has been a real pleasure. And I'll pass over to Kendra for our next topic.
Then we wanted to share, Kendra Berkey for the record, some potential ideas for legislation. And going along with the lines of that last bill, now that the records are supposed to be sealed at 18, we have concerns with how this will impact a juvenile if they come back into the justice system as an adult. Currently, our practice, if somebody is convicted of a felony or gross misdemeanor at their sentencing, the Division of Parole and Probation will provide what's called a pre-sentence investigation report to the court. Contained in that pre-sentence investigation report is someone's criminal history. Previously, the criminal history, depending on the person's age, may include some of their juvenile history. So someone could be before the court for a gross misdemeanor offense that they are over the age of, let's say they're 21, and their juvenile history, so what happened before they turned 18, would be provided to the court. Given the posture of this legislature and really wanting to ensure that children have second chances, we believe that the next progression would be to ensure that the juvenile history is not allowed to be provided in that pre-sentence investigation report. So we believe that that could be done through NRS 176.145, which discusses what can be contained in that pre-sentence investigation report. It's been allowed to be provided to the courts through NRS 62H.030, which permits the inspection without a court order of records which have not been sealed. And so we're hoping that in combination with those statutes, we can ensure that those children, when they are then adults, and if they do happen to come back before the criminal justice system, that those records are not contained in that pre-sentence investigation report, because they should be assailed and the following court should not have access to them, just like they were if it was like a 26-year-old going before the court. The court wouldn't be allowed to see that prior juvenile history. And then I'll turn it over to Ms. Fraser to discuss consent decrees.
Thank you, Kendra. Jennifer Fraser for the record. We have some ideas on improving the consent decree, but first I'll explain what a consent decree is. Pursuant to 230, you'll find the statutes headed under the informal supervision. So specifically a consent decree, the way juvenile justice, you've heard a lot about diversion and informal supervision. Consent decree is considered an informal supervision, but it's under the heading of the court being able to refer for a consent decree. Specifically, that the DA, it says the statute allows for the DA to file a delinquency petition with the court. So these are cases that are out of the harbor, out of diversion court, and the statute provides that the court has options to either dismiss the petition and refer the case to probation for informal supervision, or place the child under the supervision of the court by way of a supervision and consent decree. In these instances, the child is not adjudicated delinquent and not placed on formal supervision. This type of diversionary tool is particularly helpful for jurisdictions not in Clark County. As you've heard all morning, we have a lot of diversionary practices. The harbor helps us out. I've been at the PD's office since '06. Before the harbor, a lot of our low-level cases that are now being handled in the harbor were consent decree cases. So I think the consent decree would be a useful tool for our other jurisdictions, including rural jurisdictions. But there's an issue within the statute that although it allows the court to refer for informal supervision, the district attorney has to provide approval. And we believe that that poses separation of powers issues, allows the state to, basically that's not giving the court the power to do it, it's giving the state the power. And I know that has raised some issues in Washoe County, so I'll pass this along to Ms. Bershey to discuss.
Thank you, Kendra Birchie, for the record. And it's exactly what was just discussed we believe that this is a tool that can be used by judges to make sure that cases are receiving those informal treatment. And so our goal with what we are hoping to see in proposed legislation is just giving that power and that discretion to the court. And so what's set forth in NRS 62C.200.1b is it requires the written agreement from the district attorney. We believe that that is a violation of separation of powers, which is exactly the issue that this body took up in the 2019 legislative session based off of the Hearn decision within Assembly Bill 222 with the Veterans Court Program. And so we're hoping that this body would look into that issue to just, again, give more discretion to the court to utilize those consent decrees for those jurisdictions that do not have the amazing diversionary programs like they do in Clark County. We're hoping that this would really help to increase access to justice and really just present more of an equal opportunity for all of the individuals across the state to have that ability versus just those in Clark County. Then for our next suggestion for potential legislation, we would like the court or the legislature to consider actually imposing some probationary term limits. What we currently have is there's no defined term limit in juvenile justice cases. So for example, a 13-year-old, there's nothing in statute that says that if they come before the court at age 13 of when they would be off of probation or even when they could be looking at being off of probation. Other jurisdictions, and I'm happy to provide more information to the members of this committee, have set various different terms. Some of them are 6 months terms. So we don't have a best answer yet for this body of what we think would be the model legislation, but we think that based off of what had occurred with Assembly Bill 236 from the 2019 legislative session, that this is also a natural progression of that bill to impose some probationary term limits in these cases so that we can have that information for children who are involved in the system. And I'll turn it now to Ms. Fraser.
Thank you, Jennifer Fraser. For the record, we would echo those sentiments. Currently in Clark County, we do have term limits. The average is 6 months for the average case. More serious cases could be up to 12 months. Per statute, some juvenile sex offenses are 36 months, and then others would be anywhere from 1 year to 3 years. So we are a jurisdiction that has term limits, but as Kendra indicated, there's nothing by statute that guarantees that. So we would like some statutory help with that. Related to the probation term limits is what we see as an issue with restitution and probation. Currently, probation terminates when all terms and conditions of probation are completed, except if a child has a restitution balance. The court order, there has been legislation within the past several years that allow the juvenile court to issue a civil confession of judgment for any of those outstanding balances for fines, fees, and restitution. Once the child turns 18. But you have children who might have committed an offense that caused damage when they were 13 or 14, and they would remain on probation until they're 21 or until 18 when a civil confession of judgment would be ordered. This impacts children of lower socioeconomic status. A child who struggles to pay or his family cannot pay, that child stays on probation longer than a child who has means and can pay. Our request is that a child would not have to remain on probation if restitution balance is owed. It would not eliminate the restitution order. It would not eliminate the ability for a civil confession of judgment to be triggered at 18, but just to allow the child to terminate from probation. I would note in the adult system, adults who have not paid off their restitution balance do not remain on probation or parole, and we think this would be a positive move forward for our kids. We were talking about, I heard Assistant Director Wheelahan talk about incentives for kids, and it's a huge incentive to finish probation, to know that you accomplished it, you didn't get into trouble, you completed all of your terms. And I think it's an anchor on a child to keep them on probation for potentially years, even if it's considered, if they transfer it to like a probation without supervision, that's still an anchor on that child simply because of a financial issue. And I think that's it for our suggestions. And we just have some closing thoughts regarding our kids and mental health. I know in the news recently, there's been a lot of stories about issues in school, increased incidences of violence. And I don't think that can be discussed or looked at without really talking about mental health. And I think that's something that all of the presenters can agree on today about the need, the increased need we see. I think with our kids mostly being out of in-person school for almost 2 years, what we know, what the social science and the brain science tells us is that kids learn from each other, socialization skills, emotional development skills, and that just wasn't happening for the past 2 years. We have kids who went from elementary school right into middle school during the pandemic. We have kids who jumped from middle school to high school, and those are huge milestone developments that were happening in those periods, and it just didn't happen with them together. They were in isolation. They didn't have the extracurricular activities. They didn't have the mental health services in place, and I think we're seeing the effects of that. Kids are stuck in homes, and as we know, as I know from what I do, a lot of those homes aren't positive places for those kids. We know that a lot of our citizens have struggled during the pandemic. There's been recent articles talking about Las Vegas being one of the most stressed cities in the country. Those are our kids' parents. Those parents were, having stresses from finances, out of work, COVID, health concerns, and all of that is being absorbed by the kids at home. So when we see these increases in mental health issues and violence, it's unfortunate it's happening. I don't think it's a surprise knowing what we know and what we've been through for the past 2 years. Recently, I was in court this week, and a child was struggling with some academic issues, and the judge referenced that, a lot of our kids are having to catch up academically academically from the past 2 years. And I think they also are catching up socially. And I do think that we need to allow them to do that developmentally and increase services for them to help them succeed and to catch up from the past 2 years. And I'll pass it over to Kendra. Thank you.
Thank you, Kendra Birchie, for the record. We just want to echo that we really hope that this legislative body, when you are considering your bill draft request for juvenile justice, keep in mind that mental health needs to be at the forefront, that we need to provide more services to these children. We need to figure out how to get them more services. In Washoe County, I'll echo the statements that were said before of how difficult it has been to keep kids in Nevada to receive treatments, especially with really important programs like Hand Up Homes being closed. So this is definitely something that we hope that you are willing to look into, and we hope to continue to work together to step up for our children, because the future obviously depends on ensuring that we invest in our children to make sure that they grow up to be the best citizens that they can be, so that Nevada will continue to thrive rather than suffer. And we hope that this answers some of the questions on what has been going forward after the last legislative session. But if you have any questions, our contact information is provided in the slides, and we would be open to any questions that the committee has.
Thank you both so much. That was really informative, and I appreciate your suggestions at the end, because as you know, this committee will be looking at some bill draft requests in August, and so it's always good to get started on that earlier rather than later. Do members here in Las Vegas have any questions? All right, Assemblywoman Nguyen.
Can you just clarify, you were talking about the record of, I guess, juvenile records being included in the PSI. I thought we don't include them in the PSI any longer.
Kendra Birchie, for the record. So what we've seen is, depending on the adult's age, so if they're under the age of 21, it's been included. And so we're hoping that with this new legislation of AB 251, that will solve some of those issues, but just want to make sure that it's very clear that it cannot be included in the pre-sentence investigation report, regardless of how old that individual is.
Are you seeing that? Because it was my understanding they shouldn't be included as of the first of the year. Are they still being included in PSIs?
Kendra Birchie, for the record. I can't answer that as of the first of the year. It's my understanding that it was, but I will get back to you just to make sure. I haven't seen it in any of my cases, but this was something that my office had put forward as something that was important, but I will double check and get back to you.
Jennifer Fraser, for the record. I know that was an issue that we kind of put on our radar at the beginning of the year to look out for. I didn't specifically, when working on this presentation, get to talk to Mr. Pirro about that, and I can follow up. I would note, we heard testimony earlier, there is a backlog in sealing, and so they started with the 20 to 21, 19 to 20. So I think there is potential that those records of that age group that hasn't been sealed could still be making it on. But I don't have specifics, and we could certainly, I'll talk to Mr. Pirro and we can get that information.
Thank you. That'd be great if you could follow up. I'm sure the other committee members want to make sure that the legislation we pass is actually being implemented.
Indeed. All right. I don't see any other questions here in Las Vegas. Do we have any questions from Carson City? I don't see anybody raising their hands. What about online? Any of our members online have any questions for these presenters?
Thank
All right.
you, Chair. Just a quick clarification. I was off for a little bit, so pardon me for asking you all to back up just a little and explain to me the vape pen. I know that we had passed legislation that was sponsored by Assemblywoman Danielle Monroe Moreno. Could you just explain to me what's going on with that? What's the differentiation and how that's being handled, please?
Kendra Birchie for the record. I'll join in since this is really right now what I've seen as the Washoe County issue of the district attorney's office is deciding that there's a difference between marijuana versus if there is a vape pen, so concentrated cannabis. And the statutes do allow for them to not utilize Assemblywoman Danielle Moreno's bill and having everything being in that diversionary state of having the informal probation when it is a vape pen. And so if someone is on campus with a vape pen, they are looking and they're facing then that felony charge rather than getting that benefit of having it treated just like marijuana.
Thank you. So just a little bit further clarification. Was this an unseen consequence from that law? Was this unexpected that the concentrate could be excluded? Or is this people having the agency to decide?
Kendra Birchie for the record. I can say based off of my recollection of all the discussions regarding AB 158, there wasn't a distinction between concentrated cannabis and marijuana. It's my understanding that the intention was to encapsulate all forms of marijuana to be utilized under this bill to make sure that all children across the state of Nevada are receiving equal forms of treatment in terms of how their case progresses. So I think that it is an unforeseen issue that's now coming forward, and especially when you look at how it's just being resolved across the state. So I do welcome the remarks that were provided by Assemblywoman Danielle Moreno regarding the intention, and I do hope that either her or this body does look into fixing that issue.
Thank you. I appreciate that because when we were discussing it in session, I didn't think that there was any delineation. And so I'm kind of surprised, but I appreciate the clarification. Thank you so much.
All right, thank you for asking that question. I don't see any other questions in Las Vegas, Carson City, or online. So that will conclude this presentation and agenda item number 8. Thank you so much for joining us. And that will move us to agenda item number 9, an update from our friends at the ACLU, who I think are up in Carson City. And it looks like someone's sitting at the table, so I will let you go ahead. I'm not sure if it's Ms. Wellborn or somebody else.
That is Ms. Wellborn.
It is.
Great to see you.
All right.
I'm Holly Wellborn. I'm the Policy Director for the ACLU of Nevada. Thank you for inviting me to come and talk a little bit about some of the work that we have done in this arena. I do want to say at the outset that I adopt every statement that's been made by Ms. Frazier and Ms. Birchie. Those are different issues that we also work on and support several different entities such as the Mass Liberation Project, our colleagues at the public defender's offices, in moving forward with a lot of those policies. So we do also recommend the legislation that was brought up through that presentation. But I do want to focus on the other consequence, when we're talking about these direct file statutes, when we're talking about these certification statutes, we also need to consider where we're housing young people who have been tried as adults. This is a project and an issue area that we have been working on for about 15 years and trying to change our statutes to address this issue. So, I think background, I'm going to spend a lot of time talking about background because I think it's important for the committee to understand the origins of this issue nationally. Some of the case law is very important for our analysis in what we're looking at, and understanding where kids are currently housed is also incredibly important. So when a child is sent to the adult criminal legal system, either through the direct file statutes or the certification process, those young people are automatically sent to an adult correctional institution. So pre-trial, in Clark County, a young person is sent to the youth pod. We've seen the youth pod. We've been in the youth pod. There's, educational instruction and other more age-appropriate activities for those individuals in Clark County. But when you branch out to, let's say, Elko County, young people are held in isolation units pre-trial at one of the local jails due to the Prison Rape Elimination Act and other federal laws. That's the same case for Washoe County, where currently there aren't any suitable facilities for young people who are sent to the adult system. So the alternatives would be putting those young people in the infirmary while they await sentencing. Or, but fortunately, Jan Evans and the Juvenile Justice institutions up in the north do retain kids pre-trial at the youth facility until they are sentenced as a matter of policy, as a matter of practice. We talked a lot earlier about the many discoveries in adolescent brain science that demonstrate that youth are physiologically, psychologically different from adults. This discovery has led to many reforms in the juvenile justice system, including limitations on solitary confinement of youth, abolition of the death penalty for juveniles, and ending life without parole sentences. The end of life without parole for juveniles is operative in our consideration when we start having this conversation. A lot of the times when I engage with lawmakers on this particular issue, people really focus on the intensity or the egregiousness of an offense that leads a young person to end up in adult court. The response to that is we have effectively, through United States Supreme Court precedent and through state law, have abolished the life without parole for juveniles. The landmark case of Miller versus Alabama held that the imposition of a life sentence for juveniles is a violation of the Eighth Amendment. And then subsequent case law in Montgomery versus Louisiana expanded this and states that youth at the time of offense weighs in favor of parole. This means that every young person who is transferred to the adult system will eventually have a parole date. They will be released to the community. But right now, in the way that in the places that we house young people, and the manner in which we try to meet those young people's needs, we are not preparing them to enter society because they are living in isolation. All stakeholders agree. We've been working on this project for a long time. We issued a report, which I have submitted for the record, so all of you should have gotten a copy of that. It's called Youth Confinement in Nevada. What we ended up doing was an assessment of all juvenile institutions throughout the state, most juvenile institutions throughout the state, those that are most likely to house one of these young people when they are transferred over. We used a minimum standards assessment, not a best practices standards assessment. I want to make that entirely clear that our analysis back in 2018 when we looked at this, we weren't in there looking to see whether or not juvenile facilities in the state of Nevada are perfect or meeting, best practices standards, but are they meeting minimum standards to meet those physiological and physical needs of a young person in order for them to appropriately develop and to be successful for life when they leave prison, or successful for life outside of prison. What our conclusions were at that point were that adult institutions are not an appropriate placement. So let's start by looking at Lovelock Correctional Center. So once a young man is sentenced, they are sent to the Nevada Department of Corrections, and they're put in the youth pod at the Lovelock Correctional Center. That is a private unit. At any given time, there are about 18 to 23 boys who are living in that unit. When we first embarked on this project, the conditions were very poor. They, because it's in an adult facility, the Prison Rape Elimination Act requires sight and sound separation between young people and other adults. And that sight and sound separation can be accomplished either through isolating young people away from the adult population or by having appropriate staff ratios. Due to budget constraints, there aren't appropriate staff ratios at Lovelock Correctional for young people to engage in programming throughout the day. So we were looking at kids in Lovelock spending anywhere from 20 to 23 hours in that isolated unit amongst themselves every single day, with only 1 day of outdoor recreation, because the practice is to shut down the entire facility in order for the boys to go outside and get some physical exercise. When we first started looking at this under the leadership of former Director James Zarenda from the Nevada Department of Corrections, we had a conversation about what can we do to more humanely address the needs of young people. And it was very much his position at the time that the NDOC in Lovelock was not at all the appropriate place for these kids. And here today, I am yet again testifying at an interim committee about these young boys who are living in a place that they should not be living. As for young women right now, once they're sentenced, they're transferred out of state. There is no placement for young women in state, so they're sent away from their families, mostly in Arizona right now. At one time, there was some discussion of placing a portable housing unit on the campus of Florence McClure. And there was one girl at the time who qualified, so she would have lived in isolation for 3 years until she reached the age of majority. So, that's the picture that we're painting here of how we are failing young people by keeping them in adult institutions. When all of the evidence suggests that retaining young people in juvenile institutions, regardless of whether they've been transferred to the adult court, is better for public safety. In Washington State, the recidivism rate for young people dropped by 25%. In the state of Oregon, the recidivism rate dropped by 20%, and in Virginia by 30% when they retained youth. The outcomes for those young people were exponentially better. We're grateful for the number of stakeholders who have come to the table on this issue. We've talked with the district attorneys. We've had conversations with the Juvenile Justice Oversight Commission. And what ends up happening is we keep coming back to the legislature with proposals to review and analyze what bed space looks like, what the cost would be to transfer funding from, let's say, the NDOC to Division of Child and Family Services in order to find more appropriate placement. So I don't think that there's anyone who agrees that adult institutions are the right place, but the disagreement is what will this cost and what will it take? Some of the background here, there's been a lot of legislation that has sought to just outright, outlaw the practice of sending kids to adult correctional institutions. There's also been, bills that have been proposed to retain them in the juvenile institution until they've been sentenced. Lots of different creative ideas, but really what it comes down to is how are we going to analyze bed space and shift funding around in order to make this possible. There are now a total of 19 states that retain youth in juvenile correctional facilities, and they're seeing a lot of success. There are a lot of different models. When a couple interims ago, we brought some folks out from Washington and Oregon, and they testified before the Child Welfare and Juvenile Justice Committee, the former interim committee that Mr. Guinan spoke about earlier, and talked about the success of those programs and the different models that exist to get this off the ground. Some states will have correctional officers from the NDOC who actually work in the juvenile facility to work with some of these kids that might have more egregious offenses and need different therapeutic services or level of supervision. But by and large, there is no difference between a child who commits an offense that gets them transferred into an adult court and a child in the juvenile system. Fundamentally, the way that they learn, that they develop, the needs that they have, it is all the same. So where are we at now? Oh, I quickly wanted to, to the demographic conversation, I wanted to point out some of the racial disparities of the Lovelock boys in particular. 11% of the population are white, compared to 48% of the general adult prison population that are white. 61% are black, compared to 14% of the adult population that are black. 22% Latino, compared to 29% of adults, and 6% Asian, and then the rest, compared to 3% Asian in the adult population. So it's not only racial disparities in the way that we sentence youth, but even compared to the adult prison population, we're seeing that these transfer statutes that get these kids into an adult correctional facility for crimes that mostly include robbery with use, which is a deadly, serious offense. But we're talking about moving boys to the prison that houses convicted sex offenders. This is the system that we have set up in the state. So with stakeholder help, last session we pushed SB 365, which would have established a pilot program that would have moved 10 of the boys down to one of the DCFS facilities. But unfortunately, that bill did not move forward. It had a $2.4 million fiscal note in order to establish the program. And so the backup bill to keep this conversation going and to really understand what beds are available, how much will it cost, what types of cost sharing agreements can we enter into between the DOC and juvenile service providers. We were able to push through SB 356, which requires the Juvenile Justice Oversight Commission, the NDOC, and DCFS to analyze those points so we can start moving this forward. There's also SB 357, which requires the Nevada Department of Corrections to keep various data on the people in their custody, the young people in their custody. So, with that, I think the main primary recommendations that we have, of course, the ultimate goal and aim is exactly what our friends at the public defender's offices said, that we have to do everything we can to limit transfer, period. But we also have to do something to address the inhumane conditions that young people are living in the state of Nevada and the systems that we have set in place. And we can do that through legislation. I do think that passing a bill that's requiring the state to retain youth, at least pre-sentencing, is incredibly important. And of course, we will need to advocate for budgetary considerations to get some of that money moved in order to find bed placement in a more appropriate and suitable institution for young people. And also, we're open to talking about things like what Ms. Duffy had talked about with, looking at different sentencing structures to retain youth in juvenile institutions. But by and large, we've pushed this out for several interims, and it's really time to get moving on this. And so I'm happy to talk to any members of this body. I think really diving into some of the data from other states to see the success of this program can make people feel more comfortable with it. But it's past time that we find a solution. So with that, I will take some questions. Thank you.
Thank you so much. Are there questions from Las Vegas? I'm not seeing any, so we'll go to the internet first. Any of our members online have any questions? All right, go ahead, Assemblymember Summers Armstrong.
Okay, I'm having tech problems. There we are. Okay. Can you give me an idea of what we're talking about time-wise? Just on average, how long between a time that a child is arrested and in custody and when they go to trial and can expect to have a verdict? Just so I know how long we're talking about retention in youth facilities if we just did the one thing, which was retention in the youth facility, if anything, if they're convicted. So can you give me an idea about that?
Sure, I could give a loose idea. We did get some presentations from the counties on with some of those stats earlier today, and I think they were in their presentation, so I can get the concrete numbers for you. But it does seem to vary county by county. For the certified youth, you're looking at, I believe what they had said earlier on the record was about a 6-week turnaround to go through that certification process before there's a determination to move the child to adult court. And then the turnaround for the direct files, the kids who commit offenses that automatically send them to the adult institution. I actually don't know that we had, that people spoke to that, but I think it's within a matter of a week or a few days once they make that charging decision.
So are you suggesting that there be a differentiation between which group the certification and direct file would be retained, or all? Just help me understand.
I'm sorry, I don't understand the question. Do you mind if I try to rephrase? So
okay, I probably asked it wrong.
No, it's okay.
Sorry. So you had mentioned before that you all would like to see legislation that doesn't put juveniles in adult facilities at all as an option, or retaining them in juvenile facilities pre-sentencing.
Mm-hmm.
So I'm trying to figure out an idea of the period of time they would stay in the juvenile facility for the entire process, both during the process of certification or direct file and trial. How long are we looking at?
Got it. Thank you for clarifying. I appreciate that. Holly Wellborn for the record. I think it's best for me to circle back and talk to our friends in the public defender's offices to get some more clarity. But I think depending on the trial process and how long it takes to move through that, what that proposal would be if we were talking about something pre-trial or pre-sentencing, it would be that time frame between the moment that a person is charged and the moment that a person is sentenced. And so, I mean, that can range from weeks to a few months.
All right, any other questions from our members online? Not seeing any, so we will go to Carson City. Are there any questions from our members in Carson City? All right, I am not seeing any. So thank you, Ms. Wellborn, for your presentation, and much like the public defenders, for providing us with some policy solutions for the upcoming session. We appreciate it and look forward to talking to you about them more. And that concludes agenda item number 9 on today's Interim Judiciary Committee. And that brings us to agenda item number 10, which is public comment. Again, everybody wishing to make public comment will have 3 minutes. So we will go ahead and start with anybody here in Las Vegas. I'm not seeing anybody in person. Is there anybody in person in Carson City wishing to make public comment? Not seeing anybody, so we will go to the phones. I've also been informed that we're on a little bit of a delay. So today we're going to wait about 5 minutes, 3 to 5 minutes with the phone lines open to make sure that there's nobody waiting to give comments. So if we can go ahead and open up the phone lines now. Is there anybody there already, BPS?
Chair, you have one caller in the queue so far.
All right, then let's start with that one caller.
If you would like to participate in public comment, please press *9 now to take your place in the queue. Again, if you would like to speak in public comment, please press *9 now.
Hi, Jim Hoffman, Nevada Attorneys for Criminal Justice. I would like to thank the presenters first, especially the public defenders and the ACLU, and then Mr. Whelan. I found that presentation very interesting. My policy comment is about this issue with juveniles being in the adult system, being certified or direct filed up to adult court, and then being placed in adult detention facilities. There are a couple of numbers that I wanted to introduce into the discussion from studies. Juveniles in adult prisons are 5 times as likely to be sexually assaulted as juveniles in juvenile detention facilities. Juveniles in adult prisons are 36 times as likely, 36, to commit suicide as juveniles in juvenile detention facilities. And so to me, those are both, I mean, you know, anytime a juvenile is sexually assaulted or commits suicide, that's too often. But those numbers are so severe and those disparities are so severe, I think that imposes a duty on us to look for policy solutions. And so I think eliminating certification or restricting it more sharply, or else finding the funding somewhere for more dedicated juvenile beds, I think those are both morally incumbent on Nevada as a state. So I'd urge the committee to look at those solutions. Thank you.
Chair, you have no more callers.
All right, since our first caller was so brief, it wasn't even 3 minutes, we are just going to wait for a couple of minutes to make sure that there's nobody wishing to make public comment that's on a delay. Thank you. All right. I think we have been on the line for about 4 minutes now. BPS, is there anybody else wishing to make public comment?
Chair, your line is open and working, but you have no callers at this time.
All right. Well, thank you for bearing with us. Thank you for keeping the line open. That brings us to the conclusion of today's meeting. We have a twofer in May. We are meeting again a week from today on May 13th. And the agenda for that meeting, I think I just approved, so I think it will be posted shortly. And we look forward to seeing many of you there again, as well as in June and July. Oh, thank you. And next week on the 13th, we'll have a little bit of a later start. We're planning to start at 10 a.m. on Friday, May 13th. And I think that's everything. This meeting is now adjourned.